All right, we're live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we will be hearing today are Justice Eric Nyman and Justice Marguerite Grant. The first 3 matters are criminal matters. We will take a brief recess after the conclusion of the argument in the 3rd case before we resume with the remaining 3 civil matters. The first case on our list for hearing this morning is case number 2019 P916, the Commonwealth versus Patrick B. Malone. Mr. Smith, you may begin.
Good morning, Your Honors, and may it please the court. It's my privilege to represent Mr. Malone in this appeal. The judge, in ruling on the motion for required finding, essentially relied on Commonwealth versus Cooley from 2017. I would suggest actually Cooley, upon a closer examination, Cooley is actually probably a mountain of evidence compared to what transpired in this case. I mean, in Cooley, there was direct evidence, certainly very strong circumstantial evidence at a minimum, that the defendant there had knowledge of the gun. In fact, there was gunpowder on his leather jacket, as well as other evidence as well. And that simply is not the case here. Cooley also, I would suggest another distinguishing factor, if you will, in Cooley, is that Cooley transpires over a course of time. I mean, what we have in this case before us here today is something that happened in an instant. And so we had 2 Commonwealth witnesses. Number one, I would say their evidence does contradict each other. Their testimony contradicted each other. But it isn't just that. It's also the fact that the one, Artie, the gentleman who was present, Artie, he himself, I mean, his was really what the Commonwealth was hanging their hat on here. And
Mr. Smith, let me interrupt you for a minute. I do have questions about Cooley, but let me ask you 2 background questions first, okay? My first question is, had second-degree felony murder not been abrogated under Brown, do you agree that there was enough evidence here under Lattimore to sustain a verdict of second-degree murder under a theory of felony murder?
Under the old paradigm, yes, if you will?
Yes.
Actually, no, because the problem is there is not enough here from which it can be inferred that my client was cognizant of a robbery. There simply was not. If you
assume, and we'll let you get there. Assume for purposes of my question that under Lattimore there was enough evidence to show that he participated in an unarmed robbery.
Well, I think I'm a little unclear, but I think, Your Honor, you're getting to the issue, what happened here, which is.
I just want an answer to this question. Assume that there's enough evidence for unarmed robbery. Do you agree that there would be enough here for second-degree felony murder under the prior theory pre-Brown?
If there was enough evidence for that, I mean,
okay,
the felony would have sufficed.
My next background question is, you ask us to, you say that the required finding of guilty should have been allowed. And my follow-up to that is, if we agreed with you, would the correct remedy to be to allow a finding of not guilty, or would it be to allow a finding of not guilty only as to so much that does not allege involuntary manslaughter? Otherwise said, is there enough here to sustain a verdict of involuntary manslaughter under the Lattimore standard?
I know that was discussed, I believe, at some point on the record.
I think it was effectively conceded at the time, but I'm asking what your view is.
I still think the troubling thing here is his knowledge. I mean, this happened in an instant. I don't think there's even enough that could be inferred with all due respect.
So as a threshold matter, why don't we then drill into the robbery itself? Because it seems to me that until we get beyond that discussion, we can't have a meaningful conversation on any of the other important questions in this case.
I agree. I think that the troubling thing, what I was saying before was the Commonwealth's witness, Artie, he said this was part of his testimony. The other one, which, okay, I'll concede, maybe there's sufficient evidence elsewhere from which it could be inferred that the other one was my client. But he said the other one, I believe, was maybe outside the car, maybe about a few feet away from him, meaning the shooter, I believe. He said he never actually saw the marijuana as well. So there really is not enough here to infer.
Well, but wait a minute. You know that we don't have to take each element or each parcel of evidence that came in through testimony that may be exculpatory and credit that, right? I mean, for Lattimore purposes, let me just lay out, if I may, the sequence that I think on this record a rational fact finder could have found, which is that the co-defendant, the co-venturer for our purposes, was closest to the door and was holding the drugs. He got out of the car and our defendant got out immediately after he did. There was no payment at that point. At that point, a rational fact finder could, the Commonwealth suggests, infer that the two of them understood that they were planning to leave without payment.
Well, but it's just not that simple, with all due respect, Your Honor. I mean, the testimony here was so much more opaque than that, because that gentleman already also testified, and I'm using him in the light most favorable to the Commonwealth, because I think if you look at the other witness in the light most favorable to the Commonwealth, the problem is the other witness said that my client did not get out of the car. So looking at Artie in that light that's most favorable, he also said he really couldn't be sure. So, I mean, is that enough?
You don't need to take all or nothing even to his testimony, right? You know that.
I'm a little unclear what that question is, but I would say, I mean, I agree with the premise. Sure,
the Commonwealth, for purposes of Lattimore, and you may not like it, but the Commonwealth gets to cherry pick the parts that are most favorable to it and disregard the parts that may be less favorable, even if they're undisputed, sure, even if it's contradicted by testimony from other witnesses.
No, I don't disagree with that. But again, the problem is, the way you outlined it, Your Honor, I mean, it's rather straightforward, right? Like the other guy,
robbery, yes,
right, but that's not what this record was. I mean, the judge himself said it was particularly underwhelming evidence. I mean, the judge was there, we were not. So, I mean, I think the judge was left with the impression that this.
But you're weighing evidence, Attorney Smith. That you're weighing evidence by definition and talking about the strength of it. So under Lattimore, there is evidence that your client is in the middle of the car. He gets the marijuana, hands it over to the co-venturer. They both get out of the car, and a split second later, your client's co-venturer shoots the victim and kills him. You need to accept that for purposes of at least of this question, if not a Lattimore analysis. They were also stealing a $4,000 valued asset, according to court testimony. Why, when you also include the pre-planning, as evidenced by the texts and the communications, why is that not enough to sustain a conviction for unarmed robbery? Accepting those facts.
The pre-planning, Your Honor, was a absolutely solid case for a drug transaction. That's number one. There was nothing in the pre-planning indicating that there was some sort of discourse whatsoever about a robbery. That's number one. Number two, again, the testimony as to whether or when my client got out of the car, it's not that straightforward. The same witness who brought that to bear said he really didn't know. So even taking it in the light most favorable to the Commonwealth. Now, I would also say, let's put aside what I just said. So my client gets out of the car. It's equally inferable, at least, that he sees the other guy get out of the car. So he gets out of the car because he thinks something's gone wrong here. So he got out of the car. And by that time, the other man, unfortunately, had already shot the victim.
You're certain. I mean, look, you can argue that, and I'm sure you did. Your predecessor counsel did to the trial judge. Again, we're not going to substitute our view of the case or even weigh the evidence, but while the trial judge may have commented that this was an underwhelming case, the trial judge nonetheless, on the same record, concluded that it was enough. And viewing the evidence in the light most favorable to the Commonwealth, I have to say that I don't see a glaring hole in that conclusion. Why don't we talk a little bit, because you've got 5 minutes left. I think there are some other questions that go to the execution of the murder, which I think is the larger question here.
I'm sorry, I had a little bit difficulty hearing that, but I
Well,
think
I think that we spent a lot of time on the predicate robbery, but I think we do need to spend a little bit of time hearing your thoughts on the knowledge as it relates to the murder, independent of the robbery.
right, you're right. I mean, you broke up a little, but I think I get the gist of your question. Yeah, and that's another thing that goes back to what I said in terms of this distinguishing Cooley. In Cooley, there was ample evidence that the co-venturer had knowledge of a gun. I mean, it was both forensic and it was on his jacket. Here we don't have that. So here we have it's basically an instantaneous shooting
Counsel.
out of the blue.
Counsel, if we had evidence that after the shooting, this defendant was involved somehow with disposing of either the firearm or the Warren Sapp cell phone or both, would that be evidence that the joint venture was ongoing? Would that add to his knowledge of the gun?
I mean, I suppose it might. I think you just sort of need more facts. And I think in Cooley, and I think looking at this case and looking at Cooley together, both juxtaposed and in tandem, is instructive in that regard. Because in Cooley, again, like I said, it's a much longer sort of drawn out factual scenario, Your Honor, and which goes to your question. In this case, it's not. It's an instantaneous shooting in cold blood by the shooter. He gets out of the car and he shoots, and there's no evidence at all that my client had the knowledge. Now, I understand the Commonwealth's argument also as well. The GPS evidence tied him to being back at the apartment complex after, but it's speculation. I mean, we don't know what that really meant. I mean, the fact of the matter is there was testimony, all the men except one bolted from the car. So we don't know what happened at that point. My client could have been held at gunpoint. We don't know. In cases like Cooley, there's usually at least something more. I'm not saying that this is a slam dunk either way, but in Cooley and other cases, you have more. You just don't have that in this case.
Let me ask you a question about the instruction. Much of your argument vis-a-vis the second-degree murder conviction is predicated on either the absence of an instruction about knowledge and your argument that the Commonwealth must prove that your client had knowledge that the shooter was armed. Have you read Commonwealth versus Britt? It's 465 Mass at page 100.
I'm sure I did. It does not off the top of my head.
What it says is neither possession nor use of a firearm is an element of murder in the first degree based on deliberate premeditation. Therefore, in cases tried hereafter, juries should not be instructed that the Commonwealth must prove that a joint venturer knew that the principal was armed to return a conviction of murder based on deliberate premeditation. So how do we get around that?
Well, here the theory was the armed robbery. Here the theory was that it was required because the armed robbery was charged.
But only unarmed robbery went to the jury.
Correct. But I don't know whether there's any precedent one way or another on that issue. I would argue he was indicted for armed robbery. I would argue the Commonwealth tried it on an armed robbery theory. So I would also argue, therefore, the Commonwealth doesn't get the benefit of, well, the judge reduced it down to robbery. I mean, I read that
under that theory.
The instruction turns on how the case went to the jury.
Right. Under that theory, if your client was charged with first-degree felony murder, was ultimately convicted of larceny, you would be arguing Commonwealth didn't prove deliberate premeditation.
I'm sorry, I really couldn't hear that.
You have a minute left. I'll let you go ahead with your argument.
In any event, as to that instruction, I mean, the fact of the matter is he was charged. I understand. I mean, the instructions to the jury are different, but the fact is it was tried on the theory of the armed robbery. I mean, whatever instructions were given, the fact that the judge reduced it down from armed to unarmed, I would suggest actually, frankly, makes no difference. Because the fact of the matter is we have to look at the evidence that was presented by the Commonwealth for purposes of that analysis. And the fact
Judge Grant has one more question for you.
I understand you're saying it was tried on the theory of the armed robbery, but it was tried on the theory of the armed robbery as a first-degree felony murder, which the judge took away in the middle of trial. And ordinarily, pre-Brown, when a judge in the middle of trial says there isn't enough for a greater offense, then what's left, what the Commonwealth's proof is a subset of the lesser offense. But as a result of Brown, by taking away the first-degree murder theory, the judge effectively added an element to the Commonwealth's required proof, being to prove malice in the middle of trial as a result of Brown. Is that fair? Is that right?
I really don't know. I mean, again, the fact of the matter is it was tied to the armed robbery. And there was no evidence that he knew that there was a gun. There was none. I mean, certainly after the fact he did. But there was no evidence that he knew before the fact. There simply was none. I mean, there was none. And when he gets out of—
Mr. Smith, I think we're gonna have to leave it there. I see that your time is expired.
Thank you, Your Honor.
We'll hear from the Commonwealth.
Good morning, Your Honors, and may it please the court. Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I would like to first acknowledge the trial prosecutor, Julie Higgins, and as well as the family of Mr. Cooper who are watching via the live stream today. I would like to start with the sufficiency of the evidence argument. And again, as the court has noted, this is viewed in the light most favorable to the Commonwealth. And I think that it's important to remember that a joint venture second-degree murder can be, the intent can be proven for the offense by inferring from the defendant's knowledge and of the circumstances and subsequent participation in that offense. And I would just like to correct one thing about Chief Justice Green's recitation of the facts earlier. I do believe that marijuana was actually handed to the defendant who was sitting in the middle back seat. And that is important, I think, because of how it played out. So first and foremost, we do have the defendant luring the victim to Brighton, which is evidenced by the text messages. The victim had even offered to pay for a cab for the defendant to come down to the TD Garden area to complete the transaction, but the defendant refused. So the victim goes out to Brighton, where the defendant and Mr. Williams are. They get in the vehicle and then they take that short drive to a secluded area where the transaction begins. The victim then hands the half a pound of marijuana, and I want to emphasize this transaction was for a pound of marijuana. That's a lot of marijuana, and therefore, you know, there's a certain gravitas to that. The victim hands the defendant in the middle back seat the half pound. The defendant then looks at it, smells it, asks some questions. While this is happening, Williams states he's getting cramped and gets out of the vehicle. And at this point, that can be seen as the defendant showing interest, trying to distract them from what is happening, and Williams is preparing for what he's about to do. The defendant then gets out of the vehicle, and Williams reaches back in, and the shot is fired. The two then both flee back to Williams' apartment. And I think
let's drill down on the unarmed robbery first.
Sure.
With specificity, what is the evidence of your client's knowledge and intent, and what is the evidence of the force here?
I do believe that the evidence to go to both of those questions is the planning. It starts with the planning and the luring of the victim out to where the defendant is. It then goes on to the defendant has the marijuana in his hands and gets out without ever talking about money, without ever showing money, without any sort of movements to procure money. There's no money exchanged. There's no money seen. The defendant gets out of the vehicle. Then there's no money handed back in the vehicle. There's still no conversation about that. Williams reaches instead back.
But why isn't that just evidence of larceny by your client as opposed to forceful larceny, which is unarmed robbery?
Because I think at the point that they get out of the vehicle, again, I do agree with my brother that it happens quickly, but I think at that point, with them getting out of the vehicle, that shows that they had no intention to pay for it. And at that time, the gun then comes right back into the vehicle. And at that point, that is an attempt to make sure that these individuals, including the victim, do not chase these two, the defendant and Mr. Williams, as they flee with the marijuana they didn't pay for.
If we accept the role of the gunman as part of the force, then why the reduction of the charge from armed robbery to unarmed robbery? Where's the force without the gunman?
Well, I think the force can be, it doesn't necessarily have to be violent physical force, right? It can be the fact that he took the marijuana and, you know, left and then ran away. I think here it shows that he had no intention whatsoever. And I would also point out that the defendant knew that he was getting into a situation where the victim was bringing friends. So he brought Williams with him because he thought that he might meet resistance or he might be outnumbered. So I think the general context of the situation as it played out showed that these two intended to take this marijuana without paying for it. And in the planning process—
Where's the show of force? Going back to Chief Justice Green's question, where is the show of force? I understand the pre-planning. I understand bringing the friend as muscle. I understand they never intended to pay for this, but the drugs are handed to them as consensually, if you will, as part of a drug deal. Where is the show of force? Where is the evidence of that?
I think the show of force comes from the exiting of the vehicle and just the general threat of "don't follow us," right? I mean, it was clear that these two were never going to pay for that. And I think that it comes from the general proposition that they got out of the vehicle, they intended to flee, and they wanted to make sure they weren't followed. And
all of that, going back to Judge Nyman's initial question, is all of that certainly satisfies larceny. I think in order for you to, again, without the use of the gun, in order for you to introduce force into that sequence, you need to somehow tie the expectation or the application of force without a weapon in order to facilitate their flight.
I understand that, but I don't know that we can. I don't know that we need to parse it down that far under Lattimore, because here you clearly have the instantaneous reaching back in with that gun. And that gun, it's not disputed that the gun was there, right? The reason that the trial judge reduced it to unarmed robbery was due to the potential knowledge being shown.
Right.
But I'm sorry?
And that is the same gap that you're going to have to overcome for the use of the reliance on the gun to provide the force necessary to move from larceny to robbery.
And I understand that, Your Honor, but I think in the light most favorable to the Commonwealth, and as the facts played out, the planning, and I do think that the planning here is very purposeful, and I think the planning along with the flight also gives credence to the knowledge that this defendant had of what was about to take place. And I think that the force here really is just the fact that they came into this transaction, bringing it out to Brighton where they were comfortable, had it done in a place where they could then flee on foot easy enough to get back to where they came from, got into this transaction, distracted the three other participants while Williams got out of the vehicle and prepared to do what he was about to do. The defendant then, still holding that marijuana, again, no payment, no discussion about payment, got out of that vehicle, and Williams reached back in to make sure they were not followed. And I think that here, even without direct evidence that the defendant knew that Williams was armed. I think the circumstantial evidence just simply shows that with the planning, he was with Williams beforehand. Williams had to arm himself beforehand at some point, and the defendant was with Williams at his apartment leading up to this transaction for quite a while.
We're looking solely. That's a perfect segue to the next step that we need to take on this conversation, because while the defendant was with Williams and Williams was armed, we've been round and round on the question of how much the defendant knew about the fact that Williams was armed. So now we're going to take this same question as it relates to the use of force to move from larceny to robbery, and examine what the defendant knew regarding the use of force resulting in the plain and strong likelihood of death, producing a second-degree murder.
Absolutely, Your Honor. And again, I would point back to the steps, the planning, the participation in the offense, and the subsequent flight. And I think there are significant cases in the Commonwealth that those three steps and the defendant's participation in those three steps are important. That's Akara, Reeves, and I think that also what's important to understand is, and I understand the defendants and the lower court judges concerned with Cooley, but I think what Cooley simply stands for is circumstantial evidence can suffice. And I think that also what's important here is, yes, there was gun residue on the jacket in Cooley, but here we also have the defendant returning to Williams' apartment and staying there for a significant period of time after the murder. And we also have that the defendant shut off his cell phone after the murder that he used to communicate with the victim. And I think that's circumstantial evidence that can also prove that he was part of this and he participated meaningfully. And I think
so
also.
Let me ask you this. Can I interrupt you?
Sure, of course.
So here's a hypothetical. Buyer sets up deal to buy drugs. Buyer does not intend to pay for the drugs. Buyer knows that the seller may be accompanied by another, so buyer brings friend.
Correct.
Buyer takes the drugs from friend and walks away without paying. Friend shoots seller, and they leave together and spend time together afterwards. And every single time we have that scenario, is that enough for murder in the second degree?
I think if you have the added facts of the planning, the luring the defendant out to where they were, the clear refusal of payment where it wasn't discussed, it wasn't offered, it was clear they weren't going to. And I know that the concern with Cooley that the lower court judge had was, do we apply this to every robbery or every drug transaction? And I also understand that. But I think here what's really important, and I think if you look at that quote that he used in Cooley that talks about a reasonable juror could plan to rob a drug dealer would include a gun where victim's resistance was reasonably anticipated. I think if you take that quote and look at the two cases that quote cites in Cooley, which are Cannon and Netto, and I'm happy to provide the court with a 16L with those cites as they aren't in my brief, but they are in the Cooley case. Those two cases then go on to talk a little bit more broadly about how the situation itself and the defendant's knowledge of the victim, the defendant's knowledge of the drug transaction, the defendant's knowledge of the victim selling the drugs could frequently involve resistance, could frequently involve a situation that would go bad.
Well, it's a $4,000 asset. There's going to be.
It is. And I think, again, as I mentioned at the beginning, I think that is a huge part of this analysis, right? This isn't a couple, this isn't a couple of small bags of marijuana. This is a $4,000 purchase. And the defendant at the beginning in the text messages, which by the way, span a very large portion of that day. They start at, I think, almost 7 in the morning and they go throughout the day on and off. I think, throughout that, the defendant is expressing that the price is good. It's $38. That's great for him. He likes that. At no point does he ever try to negotiate. And I think that's just something that, the jury could understand as a reasonable inference, could also lead to he isn't planning to pay.
So that begs this question. Assume for the sake of argument that the trial judge here allowed the motion for required finding as to second-degree murder as well, and assume he allowed the required finding as to unarmed robbery. So you just have a larceny with a resulting. Could this case have gone to the jury on the issue of involuntary manslaughter?
I think it could, and I do believe it, as my brother pointed out. I don't recall right off the top of my head where it is in the transcript, but I believe that was spoken to. I think, this was a case that the Commonwealth was dealt a hard hand, that these cases were paired for a long time and severed before trial was supposed to begin. And as your honors all know, that makes for a hard card to play when you have a joint venture theory. But I think here, the evidence is, as the trial judge pointed out, was there. It was sufficient for the Commonwealth to meet its burden for a second-degree murder. And I think taking the steps that were taken here in the way that it played out, and especially the planning and the flight, and in both ends, you have the defendant with Williams for a significant time beforehand and the defendant with Williams for a significant time afterwards. I think that's very important to remember, because the planning, he had to have that gun at some point. There had to be some conversation about how this was going to happen, because I think the circumstantial evidence, or even the direct evidence of the defendant taking that marijuana and leaving without paying, not even offering to pay, I think that really does play into the calculus here. And I think it does weigh in favor, especially under Lattimore, of a sufficient conviction.
Do you view this case as the kind of case that Judge Gaziano was referring to in Brown, where he said that eliminating or abrogating second-degree murder, felony murder in totality, leaves potential gaps in the law?
I was thinking about Brown in preparation, and I think the analysis of this case would be a bit different had we been able to proceed under that theory. Again, with the severance, things get a little more complicated. But I think here that it would have sufficed for felony murder proof bound, and I think that that should also weigh into and if I see my time has expired, if I may just complete.
Please.
Thank you. I do believe that this case, the facts of this case, though they may be mostly circumstantial, we get there. And I think given the intent that was shown by his knowledge of what was happening, even just pre or post, I think, and his subsequent participation in the actual offense, I think that gets you the intent.
I think we have it. Thank you.
Thank you.
The case, and at that point, Attorney Townsend, you may begin your argument.
All right, we are live and recording.
The next case on our list for hearing this morning is case number 2020 P268, the Commonwealth versus Raymond J. Frazier. This is the Commonwealth's appeal. Mr. Townsend, you may begin.
Thank you. Mr. Chief Justice, may it please the court, Thomas Townsend with the Commonwealth. This is the Commonwealth's appeal from District Court Judge's allowance of the defendant's motion to dismiss a charge of witness intimidation. When allowing the motion to dismiss, the motion judge noted that ordinarily intent is a matter for the jury, but she nevertheless allowed the motion. That we submit was error. The defendant here was charged with witness intimidation in almost the classic sense. He intimidated a witness. In fact, it was the victim of a rape trial who had testified in a Superior Court rape trial. The defendant had attended the trial in support of the defendant in that case, who was his brother-in-law. And on the very day that the verdict was returned, finding his brother-in-law guilty of rape, the defendant went on Facebook, armed with the knowledge he had gained in the courtroom, the victim's name, the victim's image, hunted her down on Facebook, and sent her a vile message attacking her. Not just her personally, but for her participation at the trial. And in fact, the witness intimidation statute, and it's an administration of justice statute. It's designed to protect actors in the justice system, judges, lawyers, jurors, and witnesses. And the word the statute uses is participation. It doesn't protect those individuals in a universal sense, but for their participation in the justice system.
Attorney Townsend, I understand your argument based on the statute, but of course you are aware that the defendant has raised the argument that we may only apply the statute to the extent that it operates as applied within constitutional boundaries. And in that regard, the defendant's argument, as I understand it in a nutshell, is that speech that would otherwise satisfy the language or even purpose of the statute may nonetheless not be prosecuted unless it constitutes an actual true threat. First of all, I guess I want to know whether you challenge that assertion. And secondly, to the extent that you accept that premise, I want to know how it is that you say that this would constitute a true threat.
Well, just preliminarily, as I state in my reply brief, the free speech issue was raised before the district court judge. She never got to that issue because
well, that's what you say, but there's nothing in her disposition of the case. In fact, you alluded to her comment about the centrality of intent before she ruled that the case must be dismissed. One way of interpreting that is that, in fact, she did not rely on the statute, but relied on the constitutional argument in ordering dismissal. But let's go on.
Well, I don't think that's the more reasonable interpretation of what she said. The primary argument by the defense, which was erroneous at the time, was that specific intent was required.
I understand.
She heard argument on that. Sprinkled in was, references to free speech. Nothing as
well crafted as what we see on appeal. I understand that, but the argument was certainly squarely presented.
It's squarely presented, but not reached.
So let's assume we agree with you. It was presented but not reached. What are you asking us to do?
Well, in that case, a remand would be necessary because she never got to the secondary issue.
Well, let me ask you this then, and I'm quite certain, although I don't want to make his argument for him, but I'm quite certain Attorney Levin's going to say the facts aren't in dispute. This record's not going to change. It's a de novo issue in terms of interpretation of law. Why would we send it back only to be back here a year from now with the exact same question, one way or another? Why shouldn't we decide this right now? What's going to change, in other words, if we remand?
Well, there's the general principle that issues should not be addressed for the first time in the appellate court, should be addressed the first whack.
Right. But the reason for that is to allow for a development of a full record on an issue that wasn't joined. Number one, this issue was joined. Number two, as Justice Nyman points out, the record, at least as to this question, is fully developed as it relates to the nature of the statements and the context in which they were made. The cases you cite in your reply brief really do not relate to this framework, because they in Norberg, I think it is, the constitutional claim was dismissed without comment and never even entertained at the lower court. There certainly wasn't any development of factual record, and the facts bearing on it were not part of that record. Here, the question is whether the statement is a true threat. Passing for a moment the question of whether we will or should reach the issue, for the sake of argument, why don't we have a conversation about it nonetheless?
Sure, I agree with that. And I agree that I believe that the record is complete and can be addressed by this court. The defendant in his brief mentions, well, there's a lack of clarity on whether the message here was directly sent to the victim or was more widespread. And that could have potentially affect the constitutional protection. But putting that aside, I believe personally that this record is complete and this court could address it. And so switching to that issue, I believe that this is a true threat.
Let me back up for a moment, if I may, because of course these were threats, as you say, or intimidation that took place after the witness testified. The witness intimidation statute has been on the books for many, many, many years. Do you have some illustrative examples of the kinds of statements that have been held to constitute intimidation and have been held permissibly within constitutional boundaries that are similar in nature to the statements here?
Well, I think contextually, we're looking at a statement made after the verdict, before sentencing. And so two cases I can think off the top of my head are Kathy C. and Bell, both from this court and both cited in my brief, which deal with post-conviction, pre-sentencing hearing statements made to witnesses in those cases.
No, but there were actual threats of violence in those cases. I mean, I think I was trying to give you an opportunity to expand the field, because my guess, without having done an exhaustive level of research, is that there is a larger body of factual material and examples in the pre-verdict in witness intimidation than there is in post-verdict witness intimidation. And yet all of those instances, in order to pass constitutional muster, would need to constitute true threats, right?
Well, yeah.
So my question is, what is the lowest level of threat that that has been held to pass constitutional muster, whether pre or post-verdict?
I think if we're talking about true threats, we do not have to be cabined to intimidation of the witness. We can take a look at elsewhere for criminal harassment, for instance. I think the closest case and the best case for the Commonwealth is Bigelow. And in that case, the defendant had sent letters to a select board member and his wife. And the SJC in that case said, well, it's a select board member. He's a public figure. He was asking, or that goes with the territory, to get threatening letters or offensive letters. His wife, however, was not. And so the court allowed the case to proceed, or a retrial in that case, on the letters directed to the wife. Now here we have a private person as well.
But in Bigelow, there were actual threats of physical harm.
Not specifically at the wife. It was offensive language. And if we look at the definition of true threat that's used in O'Brien, that's used in Bigelow, that's used in Cho, a true threat are words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. We have that here. And the court goes on, such speech is unprotected because its purpose is to cause injury rather than to add to or comment on the public discourse. That is here as well. This was a specific targeted attack. It did nothing to add to the public discourse. And the court goes on, a true threat does not require an explicit statement of an intention to harm the victim, as long as the circumstances support the victim's fearful or apprehensive response. Now here, clearly the victim was fearful and apprehensive. She immediately contacted the district attorney's office. She was crying as she recounted to the investigating officers what had happened. She said she was fearful for her physical safety because she had to disclose her address during the proceedings in open court. And under those circumstances, to receive this attack on the very day of the verdict, it certainly justifies her fearful response. That is a true threat. Now, the defendant will have the advantage or the benefit of an instruction at trial, saying that the Commonwealth must prove beyond a reasonable doubt that it was a true threat. This is not categorically excluded. This is a jury question, as it was in Bigelow. And that's why the court reversed in Bigelow, because the jury had not received that instruction. But in this case, the jury will receive the instruction. And whether this is a true threat or not is a factual question to be determined by the jury, not by the motion judge at this stage.
I'm sorry, go ahead.
To what degree does the sexual aspect of the statement and the underlying crime matter here? If this were a male witness who had testified to being the victim of a robbery, and the next day the defendant's cousin or brother-in-law had said, paraphrasing, "You messed my brother's life up, you lied in court, what kind of person are you? Keep your valuables locked up." Would that be a different case?
All facts are different. That potentially could be a different case. Here, the defendant was attacking the rape victim using sexual language. This is similar, I would submit, to Commonwealth versus Cho, CHOU, in which the defendant tried to get back at an ex-girlfriend by posting missing posters throughout the school. And the court held, well, there's a sexual aspect to that. And it was terrible derogatory stuff he was saying on those. But she was justified in being fearful, and that constituted a true threat. Even though it wasn't explicit, even though it was veiled, but it was sexualized in much the same way that this threat was as well.
Well, just the mere fact that she was in fear, it's an objective test, right? Not a subjective test.
Well, it can be under the harassment prong of the statute. There's an objective component and a subjective component. But I agree.
I'm not talking about the statute. I'm talking about in order to qualify for restriction under the First Amendment, it has to be an actual threat. Going back to Bigelow, I mean, the letters directed to the wife included a reference to her possible need in the future to have restorative plastic surgery to her face. That is a threat, understood in common sense and plain English. What is the closest that you have here that to that kind of a threat that the victim could be concerned about?
Well, I believe there's a dearth of cases right now because the statute was amended in 2018.
I'm not talking about the statute, and again, similar kinds of statements, similar kinds of intimidation have been on the books for years and years and years pre-trial, pre-verdict, and those likewise need to pass constitutional muster. My question is, what is the lowest level? What is the closest to the mere statement, "You messed up my brother's life," using profanity, using ugly language, that has been held to constitute a permissible criminal prosecution and not being as a true threat?
Well, I still like Bigelow. I understand that there were 3 letters in that case. Under criminal harassment, there had to be 3 instances.
But it's not the number of instances, it was the content and the nature of the threat of physical violence that I just described. I mean, again, what is it that you have here that invokes the same degree of a threat of physical violence?
Well, it could be veiled. It need not be explicit. I think
I'm aware of that. Tell me what the veiled threat is here.
the veiled threat, it's what kind of piece of S are you? Stop spreading your legs to a rape victim who had just testified.
It's hurtful, but it does not veiled or directly. It's offensive. It's deplorable, but it does not imply an intention on the sender's part to commit a second assault.
Well, it need not be explicit, and this is from O'Brien and Joe.
I know that, but even implicitly, where is the threat?
Well, as long as the circumstance support the victim's fearful or apprehensive response.
Let me try this a different way. Where in First Amendment or Article 16 jurisprudence can we find guidance as to the issue of true threats that are articulated through nuance, if you will?
I think O'Brien is.
What are the best sources?
O'Brien is a good case. That was a civil restraining order.
Yep.
I believe that one. Cho with the missing posters. There's nothing explicit there. That's all implicit. And I still like Bigelow. Those are the 3 big cases from the Supreme Judicial Court.
Right. Thank you very much. We'll hear from the defendant. Mr. Levin, you may proceed.
Thank you, Mr. Chief Justice. May it please the court, Patrick Levin on behalf of Raymond Frazier. I'm afraid I may have to preemptively apologize at the outset. I seem to be experiencing some technical issues. The feed has been going in and out on my computer for the past 15 minutes. So hopefully I'll be able to get through the argument. But just if I cut out, let me know and I'll repeat whatever I was saying. So we're asking the court to affirm the dismissal of this complaint. The Facebook message at issue here certainly was rude. It was offensive. It was insulting. It was not a threat. Better or for worse, in this country, we don't lock people up for being a jerk on social media.
This is more than being a jerk. I mean,
of a truth.
Mr. Levin, in context, it was not only rude, it was hurtful.
Yes, I agree, Your Honor.
In fact, could reasonably be construed to have caused injury to the recipient of the statement. Whether it's a threat is a different question.
Your Honor, I agree with you. It was hurtful, and he shouldn't have sent it. But that doesn't render it a 20-year felony.
Well, the question of the penal consequences is a separate question. The question of whether it is
fighting words
it
or
is
some
protected
other
by the First Amendment, it seems to me, is the threshold matter that you need to threshold hurdle that you need to clear.
Your Honor, I not to nitpick, but I agree that that is a threshold question in some sense, but the argument that I'm making here is a statutory argument fundamentally. And the canon of constitutional avoidance obviously comes into it when you're interpreting the statute. But the same language that the legislature used in this statute to define the word harassment is the language construed by the SJC and Welch and O'Brien. So in terms of I do have an as-applied constitutional challenge as well. And I argue that even if the statute does cover this conduct, that in that case, the statute is unconstitutional as applied.
I'm engaging it on that basis, but my question is, it's not merely true threats, but also words that in fact cause injury and are known to cause injury. Those are not protected either, are they?
Under the fighting words doctrine, that is one component of the fighting words doctrine, words that by their utterance inflict injury. But the SJC's case law is clear that the fighting words doctrine is limited to insults that are delivered face-to-face and likely to provoke, for that reason, an immediate breach of the peace. And so absent the face-to-face communication aspect, the fighting words doctrine does not come into play. And as the SJC says in Welch, words that are abusive or insulting or even hurtful are not, for that reason alone, punishable under the First Amendment and Article 16.
Do you agree that true threats can be made indirectly and with nuance?
Yes, Your Honor. I do agree that the threat need not be an explicit threat. I will hurt you. I will kill you in so many words. But what is required is that the totality of the circumstances demonstrate an intent to put the victim in fear of unlawful violence.
Right. Well, counsel, on that point, from the phrase "stop spreading your legs," could a juror infer, and from the fact in the application for complaint that this defendant was present at Mr. Salisbury's trial where this victim testified to sexual violence that had already befallen her at the hands of Mr. Salisbury, could a juror in this case infer that the phrase "stop spreading your legs" means what happened to you with Mr. Salisbury is your fault and it's going to happen again?
No, Your Honor, of these words that is a threat of violence by this defendant to this victim. That's what's required, and it's not present in this case.
Well, it need not be violence committed by the defendant. It could be someone else acting in concert with the defendant, right?
That's true, Your Honor.
So going back to my prior question, Attorney Levin, I'll ask the same question I asked of Attorney Townsend, which is, from the U.S. Supreme Court or from the SJC, where can we find the best guidance on analyzing what does and does not constitute a true threat made with, as I said, nuance, or an indirect true threat? Where do we find the best guidance in terms of analyzing that issue?
So in terms of the U.S. Supreme Court, there aren't very many cases. Virginia versus Black is the lead case. And before that, you have to go way back to Watts, the case about, if I get drafted, the next person I want in my sights is the President of the United States. That's the genesis of the true threats doctrine. But in the SJC, I do think 88 Townsend has pointed you to the right cases. It's Bigelow, it's O'Brien, it's Chu, and it's Welch. And then there are some restraining order cases out of they're captioned with the party's initials. It's CER versus PC and AT versus AR, or cases like that, that also shed light on this similar question. It's true threats under the First Amendment question. And to speak to the cases in particular that I agree are most pertinent here, the Bigelow case involves letters, a series of letters mailed anonymously to the victim's home. These are facts that the SJC found crucial. The persistence of the conduct over time, every few weeks for months, the anonymity of the letters, which the SJC that he intended to cause fear, the fact that the letters were mailed to her at her home, a place where she is especially entitled to be left alone. And then, of course, the specific comments in the letters that contained threats to her well-being, such as references to her needing plastic surgery to change her appearance in order to protect herself, that she should move out of her home, references to her husband having allegedly burned down his first wife's home while she was inside.
Mr. Levin, we got the facts in Bigelow. We know O'Brien, we know Chu. I'm going to, I guess, ask you whether you have conducted anything like the inquiry that I was talking about with your brother about other witness intimidation cases, because again, we have enforced prosecution of witness intimidation for many years, and I will confess that I am not aware of any serious as applied inquiry into the constitutional boundaries of permissible prosecution of witness intimidation pre-trial. My question to you is, what do you have to support this analysis, this argument, arising out of the vast expanse of factual detail in the witness intimidation statute itself? I'm assuming you're not stumped. I'm assuming you're frozen. You're frozen. We'll wait for a little while longer. Okay.
All right, we are once again live and recording.
Okay, I will ask my question again because we had a little bit of technical difficulties. My question is whether, Mr. Levin, you are prepared to relate your argument to the vast expanse of factual illustrations that we have in all of the prosecutions of witness intimidations under the statute as it applied to pre-verdict conduct. I'm not aware of this particular as applied constitutional challenge in that context, and maybe you are, but it seems to me that there are lots and lots of statements that have been successfully prosecuted as witness intimidation that may involve fairly low-level threats, if threats at all.
So, Your Honor, I do think that although the witness intimidation statute has been on the books for some time, it was amended in 2018, and the context of a prosecution for of intimidation for purposes of post-trial retaliation, as opposed to in order to interfere with the administration of the trial itself, is a sort of a different.
I'm well aware of that, but it seems to me that the First Amendment applies whether it's under the new statute or the old statute, and to the extent that only true threats may be prosecuted, it would have applied to pre-verdict statements under the old statute, right?
Yes.
Okay, and we have lots
Honor.
and lots. We have lots and lots of examples of prosecutions of intimidating statements that were for purposes of the statute. I don't know the answer to this, and I don't know whether you have undertaken this inquiry. But my question is, are there examples where this kind of constitutional challenge has been lodged to witness intimidation? And if not, are there examples where comments similar to those at issue here were successfully prosecuted without a constitutional challenge?
Your Honor, I believe in the course of briefing this case that I read every published appellate opinion regarding this statute. I am not aware of a case prosecuting statements of this nature. The cases that some of the cases, for example, Commonwealth versus Gordon, is a case where a defendant's father approached a juror in the lobby, stood uncomfortably close to her and talked to her about some violent film that he recommended that she watch. When she walked away from him, followed her and stood uncomfortably close again and talked about how his son was a good boy and hadn't done anything wrong. That's a case where there is no explicit threat of violence, but it certainly is reasonable to interpret that conduct as a true threat falling outside of the First Amendment.
Well, isn't it also a true threat, though, because he looked up and down her body and said, aren't you a fine thing?
Yes,
Doesn't
I believe that was
add
present in
component?
I believe that was present in the facts of Gordon, yes. So that in-person interaction also informs the nature of the inquiry, and to a certain extent takes it out of the pure speech category of cases.
You know, the difficulty I'm having is it's easy enough to identify instances where, in fact, the conduct would qualify as a true threat. The question I'm asking, and again, I don't know the answer because I haven't done this sweeping inquiry, but just based on the sheer number of prosecutions that would have taken place under the old statute, I have to imagine that there were interactions that qualified under the statute as witness intimidation that nonetheless would not have risen to true threat as we're talking about it here today. Now, maybe nobody ever thought of this before. I don't know, but
well, Your Honor, the Black case is from 2003, Welch is from 2006, and O'Brien is from 2012. And those cases are the cases that clarify what this proper sweep of the language of this statute is. And so to a certain extent, the broad array of case law predating about 15 years ago is not going to shed that much light on the true threat inquiry because that wasn't really a salient doctrinal question. But there have been some First Amendment type challenges raised in some prosecutions under this statute. I think McCrary or Kathy C might be one of those cases. I don't recall now, but they're pretty quickly brushed aside because the facts of those particular cases are clearly threatening. And I am not aware of any case, and like I said, I believe I've read them all under Section 13B. I'm not aware of any case where it's pure speech and it's speech of this nature, which is certainly insulting and certainly hurtful, but is not threatening.
To a man.
Your Honor, I'm not sure that the sex of the defendant or the victim is necessarily a proper constitutional inquiry in this situation. If there are no further questions, I would rest on the brief.
thank you very much. And we managed to survive the brief technical difficulties. Thank you both. The case is submitted.
Thank you.
All right, we are now live and recording.
The next case on our list is case number 2020-P73, the Commonwealth versus Heriberto Rivera. And just as a reminder, we will take a brief morning recess following the conclusion of the argument in this case. Attorney Hong, you may proceed.
Good morning. May it please the court. My name is Kari Hong and I represent defendant appellate Rivera. The trial court made 3 errors. First, on sentencing count 1 and count 2, Commonwealth v. Ashford has since clarified that under the categorical approach, ABDW is overbroad as a violent crime. Turning then to the modified categorical approach, after the Rule 30 motion at R81, the trial court appeared to accept that this offense was committed with a reckless rather than an intentional mens rea. This implied finding of fact is correct. These facts show that when Mr. Rivera was 21 years old, he was at a party, he pointed a gun at a friend, he said words that were not heard by the victim, and the gun went off. The victim stated he had no idea why he was shot because he and Mr. Rivera had no problems with one another. The trial court imposed a sentence of probation. ABDW has a maximum sentence of 10 years. Combined.
Well, Counsel, I have a question. In Ashford and in Eberhardt and in Widener, those defendants had jury waived trials to the armed career criminal count. Isn't that right?
Yes, Your Honor.
But your client he pled to the armed career criminal count.
Yes, Your Honor.
And in the record, there's reference at plea transcript 7 to a waiver form that he signed, which is paper number 54 on the docket. And that, from what we can tell from the docket, that says something about waiving his rights to the armed career criminal count. But that doesn't seem to be in the record appendix. So my question for you is your client's situation different because he pled rather than going to trial on the armed career criminal count?
I would say two reasons why. The first is in the course of the discussion of the sentencing hearing, the parties discussed the scope of the waiver, and the trial court made very clear that that does not forfeit any issues on appeal with respect to this. The second answer is that the trial court has a duty to ensure that there is a factual basis for the plea. And in this situation where the law makes it clear that this is now an overbroad predicate offense, that the trial court still has to ensure that there is a factual basis for this to be a legal sentence. So turning to count.
Your argument that that this was impermissible rests on the assertion that our Widener case was wrongly decided.
Well, yes, and that's what Ashford clarified in December 2020. That is no longer the correct analysis. And at Rule 30, the trial court expressly cited to that case. And now that that has been overturned by the SJC, it's important to apply the law as it's properly understood. The trial court said, even considering the defendant's ABDW conviction to be one based on reckless conduct as urged by the defendant, this does not change the result under Widener. Now that Ashford has overturned Widener, this sentence can no longer stand. Second, turning to count 3, on the day of the sentencing hearing, the prosecution filed a written sentence recommendation, arguing that 3 to 4 years was the proper term for the possession count involving 6.63 grams of cocaine. That's at R49. The same day at the sentencing, the prosecution argued for a 10 to 12-year term. Now, the most likely explanation is that the prosecution forgot that this sentence was different than the other 2 counts enhanced by ACCA, and given that they were all concurrent, probably just forgot about that distinction. The alternative explanation is that the trial court listened to the prosecution's arguments to increase count 3 to 10 to 12 years because Mr. Rivera did not go to college and he did not have a job. Punishing someone for a mistake is an improper reason. Punishing someone for class status is an improper reason.
Well, counsel, if the prosecutor had recommended a lower sentence in the sentencing memorandum, and then something happened at the sentencing hearing that made the prosecutor decide to recommend a higher sentence, would the prosecutor be bound by what she or he had said in the sentencing memorandum?
Absolutely not. If that had happened, that the sentence could have changed either upward or downward. But that didn't happen.
What if the trial defense attorney had said, hey, wait a minute, in your sentencing memorandum, you recommended 3 to 4. Why are you changing?
Yes, Your Honor, but still the trial court has a duty to ensure that the correct sentence is imposed. Under Monson, what happened, the prosecutor at sentencing said perjury was the reason why the sentence had to be higher than the original recommendation. This court reversed because the trial court never explained why it adopted that recommendation and why that was proper. Under Banker, we have another situation where it wasn't clear if the sentence was being increased due to the exercise of the right of trial, which would have been improper, or to your point, additional facts that could have warranted it. When there's an ambiguity, our courts say that you have to reverse and get it on the record so we understand why and we can review it. Stuckich is another example where the prosecutor argued well beyond the guidelines based on conduct. But the court said only conduct for the last 3 years, not the conduct for the last 10 years, as mentioned by the trial court, by the prosecutor, was proper.
Are the guidelines binding? Have they ever been adopted?
No, Your Honor, but you still have to give a reason. And it appears the most likely explanation is that the prosecutor forgot, because even in the defense before this court never explains why an offense involving 6.63 grams should receive the same sentence as a drug trafficking crime involving 100 to 200 grams of cocaine. There has to be a reason for that, and none was given before the trial court, none was given by the trial court, and none was given in the briefing before this court.
I have a question about procedure. Ordinarily, the review of a sentence goes to the appellate division of the Superior Court, as it occurred here. Our review comes in only if the sentence was illegal, outside the bounds of propriety and or permissibility. And I understand your argument that it may have been imposed without adequate explanation. I understand your argument. But that it may be viewed as excessive within the range of like offenses. But it clearly was within the statutorily permissible range, right?
Yes, Your Honor.
And it wasn't based on an impermissible consideration, correct?
Well, I would argue that it was. That it was the reasons that the prosecutor said it was warranted to be so high was because he never had a job and didn't go to college. Quote, he could have looked for a job, he could have gone back to school, but no.
Does the fact that the prosecutor invoked impermissible grounds mean that the sentence is illegal if the judge did not rely on those?
Well, Your Honor, that's where Banker and Monson says that when the prosecutor does invoke improper considerations, the trial court has to explain why they did not rely on that. And so in this situation, when there's an ambiguity, it has to be sent back to the trial court to explain why, in the absence of that improper consideration, this needs to be bumped up to 10 years. Now, third, turning to the motion to suppress, the record has no evidence to justify the use of force after a 5 to 8 second delay. The police never.
I thought it was 7 to 11.
Your Honor, the finding, that's what the prosecutor repeated at R40. The trial court said he made findings, and his findings were 5 to 8 seconds.
His findings were 5 to 8 seconds before the go sign was given, but then there were another 3 seconds before, I think it was 3 seconds before they actually battered through the door.
So, Your Honor, if I'm mistaken on that, even an 8 to 11 seconds, the police never gave a reason why force was justified. He had a warrant for cocaine. There was no mention of drugs. There was no mention that he was selling with any other person. The police witnessed Mr. Rivera leave the building.
Your client's argument below was that the police didn't knock and announce at all, right?
Yes, Your Honor.
And now you're arguing that if they knocked, they didn't wait long enough.
Yes, Your Honor.
But as I read the transcript, Sergeant Early testified that he knocked 3 times and then 5 to 8 seconds elapsed, and then 2 to 3 seconds elapsed while the other police came up the stairs. So my question for you is, where in the record does it say how much time elapsed from Sergeant Early's first knock until the battering ram hit the door?
Your Honor, when I read the decision on the motion to suppress, those were the findings of facts. That's where they reconciled all the different testimony.
Well, that's in part because that's the only issue that was joined, right? There was no argument based on an inadequate waiting period, and if the judge had been compelled to address the question of the period of time between the first knock and the actual entry, the judge could have done so, but because this issue wasn't raised, the judge had no occasion to address it in his findings.
Yes, Your Honor. This issue was not raised below. So the standard review is substantial risk.
But I understand that, but we do not have a fully developed factual predicate even to base that to conduct that inquiry.
Well, Your Honor, we have the testimony given by the police officers where they explained why they entered. And on this issue, they were always silent. They were given many opportunities to testify. And this is different from Bush. They never explained, they never said they had, there was a belief that they had a gun.
Once again, they had no occasion to provide that explanation because the challenge was not that they didn't wait long enough, not that they couldn't go in at all, simply that they did not knock and announce.
Your Honor, they weren't asked leading questions. They were asked to explain why they entered.
I understand that, but if the issue wasn't joined, their responses are going to be directed to the challenge in front of them.
Well, Your Honor, if you disagree with me, I'd like to point you back to the sentencing errors. Because
okay.
Because I personally believe that the sentencing errors are much stronger. And as given that he served more than 4 years of his time, his sentence already, that is a benefit that I would that would serve justice. So would ask the court just to focus then on the sentencing errors at issue.
Well, to be clear, we haven't made up our minds about anything in this case. So don't make that assumption, please.
Okay. Thank you, Your Honor.
Of course. I just have one question about the reasonableness of the, let's call it 8 to 11 second delay. Something that you say in your brief is that there was no concern that the drugs may be destroyed because the defendant was detained at the time. My understanding of the record, and this is record appendix page 32, and I think the supplemental at page 8, is that your client fled. The police attempted to follow the avalanche and attempted to stop it, but they abandoned the pursuit because it became too dangerous. And then they went and executed the search warrant. So with that big windup, my question is this: why wasn't there a risk that your client would telephone, for example, his sister and say, police are coming, get rid of the drugs?
Your Honor, I've two quick points. One, I apologize to the court. I saw that correction, and in the reply brief in a footnote made note of that I made the mistake of misreading that he wasn't detained. He was chased and then they abandoned it. So your recitation is correct. And the footnote makes note of that. To your substantive question though, is that we don't even know if he had a cell phone. We don't know if he called, and he did not see the police. We don't have any information that's pure.
But the police, in assessing, as they're standing at the door, in assessing the risk of destruction of evidence, we don't need to determine whether he in fact had a cell phone. The risk certainly was present that he would, right?
Well, Your Honor, the focus of the court is, what did the police believe? If the police believed that, absolutely, that would have been reasonable. But the police never testified that. They never said we were concerned.
That's okay.
And his sister is
earlier question though. Doesn't that beg Chief Justice Green's earlier question though, that they had no reason to testify to this because this issue wasn't raised?
Or because it didn't exist. That's the problem. And so I defer to the court on how they wish to resolve that ambiguity.
Anything else?
No, Your Honor.
Thank you. Now we'll hear from the Commonwealth.
Thank you, Your Honors. May it please the court, Donna Marie Heron, Assistant District Attorney on behalf of the Commonwealth. I'll go through the issues in order. The court wishes. Turning to the first issue, the motion judge here properly denied the motion to suppress based on the sole issue which was raised, which was whether Sergeant Early knocked and announced his presence. The whole direct and the whole cross-examination were majorly regarding whether he knocked and announced. And indeed, the whole cross-examination was regarding what defense counsel tried to argue was inconsistent testimony regarding Officer Carlson at the dangerousness hearing and stuff. The clear focus was on whether he knocked and announced. There was no testimony taken about the reason for the delay, and I therefore say this is not properly before this court. For the reasons as shown through your questioning by my sister, the record is a little devoid as to the exact reasons why the police waited 7 to 11 seconds. So I would suggest.
Heron, let's get beyond the motion to suppress. this case was fully briefed before the SJC decision in the Ashford case. I'd be interested in hearing your argument since you did not have an opportunity to present it in your responsive brief. What are we to do with the sentence in light of Ashford?
I think Ashford is very instructive here, and I think Ashford completely supports the Commonwealth's position that aiming a gun and shooting it at somebody clearly qualifies as a violent crime under the force clause. I think Ashford's instructive as it requires that the Commonwealth now needs to present an underlying factual basis under a modified categorical approach to establish whether the crime is violent under the force clause. Here, the facts, the Commonwealth during the plea colloquy recited the following facts, outlining that the victim was found unconscious on the street, was sent to the hospital where he sustained a bullet wound through the shoulder and then through the chest that lodged in his spinal cord. He was in ICU for numerous days. And most importantly, that when he finally talked to the police, he told them that him and Macho, who was subsequently identified as the defendant, were partying together with the victim's group of friends, and that he went outside, that Macho followed him, said something, and then, quote, raised a gun and shot him. That clearly qualifies as a violent crime under the force clause. And indeed, in Ashford, I direct your attention to 467, the court in their decision says, we recognize the result, we reached a may seem counterintuitive. Potentially shooting a person without killing the individual is, quote, undoubtedly a crime of violence. So based on Ashford itself, clearly the Commonwealth's recitation of facts during the plea colloquy to establish whether the defendant committed a violent crime under the force clause was met when the Commonwealth outlined that the defendant picked up the gun and shot it. And I would suggest any attempt by the defendant to try to explain or go away from the factual recitation is not allowed under Wentworth, as Wentworth at 673, by pleading guilty, the defendant waives any challenge to sufficiency of the evidence that the crime committed constituted a violent crime, meaning she can't then argue, or the defendant cannot then argue, well, maybe it was accidental, maybe he didn't mean to shoot him. The facts that he pled guilty to was that he was previously convicted of an assault and battery with a dangerous weapon and an assault with intent to kill, in which he picked up the gun, aimed it, and shot the victim. Therefore,
was the predicate for the enhancement here armed assault with intent to kill, ABDW, or both?
It was both. And the I'm going to say the name wrong, the case where you, Renzendi, I apologize if I'm butchering that, stands for the proposition that if we were to go under ACC level 2 or ACC level 3, we would need to establish two separate instances arising from separate instances convictions. Since the Commonwealth the defendant only pled guilty to an ACC level 1, all that was required was the Commonwealth established that either were a crime of violence. The Commonwealth suggests that both were a crime of violence. That's all that's required. Under Resende, if the Commonwealth had convicted the defendant as an ACC level 2, then there would be an issue since the crime arises out of a single instance and not separate instances. If
could you address the sentencing issue, please?
I'm sorry, the sentencing issue, is that what you said, Your Honor? I apologize.
Yes.
Okay. The sentencing judge here properly sentenced the defendant, which the propriety, as Chief Justice Green already noted, was already reviewed by the appellate division and upheld, where this court solely looks to whether it is a legal and constitutional sentence. And under the statute, it is a legal and constitutional sentence. And I suggest the defendant hasn't shown otherwise. The prosecutor's word she used, I suggest the defendant is taking out of context. What she was arguing, and based on Judge Ricciardoni's comments of sentencing, was clearly that the defendant had numerous opportunities to rehabilitate himself, but never took advantage of those opportunities. And she was arguing the proper basis of sentencing, which is rehabilitation. And indeed, that's how Judge Ricciardoni interpreted it when he said that the man has showed himself to consistently and repeatedly be a threat to others in society, and, quote, has a long history of not taking advantage of those chances and committing other serious crimes, which are proper bases to to consider in sentencing a defendant. I would suggest there's nothing illegal or improper, which is solely what this court looks at. And I suggest the sentence imposed and the reasons given by the judge make it a proper legal sentence.
Is there any indication in the record as to why the Commonwealth departed from the 3 to 4 recommended sentence in the memorandum and then sought a higher number at the sentencing hearing?
There's nothing clear in the record. I think the prosecutor, in my reading of the record, was solely focusing on the ACC. I don't think she even mentioned the drug charge. I think she solely was arguing the Commonwealth was recommending 10 to 12 on the ACC portion of the during the sentence recommendation part. I don't believe she even mentioned the drug offense. So based on the record, I can only infer that's where the prosecutor's intention was on, and it wasn't on the drug portion. But again, this court solely just looks as to whether it's a constitutional and legal sentence, given that it was already reviewed by the Sentencing Appeal Division and it was upheld. And I suggest this clearly is a legal and constitutional sentence. And therefore, I ask this court to affirm the defendant's convictions and affirm the sentences imposed. If there's no further questions, the Commonwealth will rest on its brief.
Seeing none, that will conclude the argument in this case. We will take a 15.
In my office is somehow acting in bad faith or in a frivolous manner solely to cloud plaintiff's title. I will set the record straight today and demonstrate how the 5B affidavit did in fact clarify title to the defendant's property. I take serious offense to the manner in which Deutsche Bank's brief was presented and the false narrative set forth in a record document before this court, just as it was presented to the lower court, which lower court judge unfortunately accepted such allegations for face value and without inquiry and made a ruling on the same day of the hearing solely on allegations presented at oral argument. The mischaracterization of this case must be addressed because Deutsche Bank has entirely changed its narrative for the simple purpose of convincing this court that it should look no further than the trial court's decision to basically disregard the confusing record and pull the rug out from underneath defendant with an opportunity to provide a defense to the claims and to the record affidavit. I just can't be silent in the face of allegations against myself or my firm's character that are disingenuous. That's one thing you can count on. The last point before moving on to substance is plaintiff's misrepresentation in the brief asserting that the land court recently addressed this same issue with myself in Bank of New York Mellon versus Garinian, cited at plaintiff's brief, page 28. And I have never heard of that case. That was not my client. And that I just want to note that.
Mr. You may rest assured that we will not assess your reputation on the basis of allegations that anyone else is making, except to the extent that those allegations are supported by the record. Why don't we talk about the substance of the arguments in this case as it relates to the issues that we need to decide on appeal?
Yes, Your Honor. I was getting ready to move on immediately. I didn't want to spend much time on that, but I did want to clear the record on that. Thank you. I think it's clear that the confusion of the lower court record. There was a motion to dismiss that was filed and docketed. There was an opposition to the motion to dismiss that was docketed, and both parties were acting on the misunderstanding that was going to be decided, whether it was going to be scheduled or the land court was going to decide it on the papers. We were waiting for that determination on a standing related issue, and it became confusing. And and I admit it, we waited till the eve of the hearing date to talk to the court about it, and the clerk suggested.
Mr. McCarter, we're aware of the facts. So your first issue, as I see it, is you say that the judge should have granted a continuance on the summary judgment motion and hearing, correct?
Correct.
Where in the record can we find, is it in the record an indication that more time was sought?
I do not think it's in the record because the transcripts weren't ordered of that hearing, but
you are the appellant, right, Mr. McCardle?
I am the appellant, correct.
Okay, so if you want that, if you want a motion for continuance to be in front of us, and you're implying that you made a request for continuance in the transcript, that was your burden. We don't have that. So you're gonna have to rely on the record that you have presented to us in order to make the arguments that you want to make.
There's a couple facts in the record. I believe it's at record exhibit 188. There's a correspondence between the court and my office.
Requesting a continuance?
Yes, regarding addressing the issue with the motion to dismiss, that we could address that at the hearing tomorrow. that there was a confusion on the record and that it would be addressed with the court the following day.
It says
That's different from requesting a continuance on the disposition of the motion for summary judgment.
Okay, I can acknowledge that on the record as is, there's no written request for a continuance. It was made.
So the protest that no continuance was allowed, I think we have to treat that as waived, right?
Okay, but I believe it's also set forth in the reconsideration motion, which is part of the record. It's I guess it's a little different treating that as a request for a continuance, and it's a little I acknowledge that that's a little odd. But I would suggest you could look to the motion for reconsideration and the request within that. But I'd like to, and even if I concede that fact, I'd really like to dive into the affidavit. The substance of the case is that this affidavit is a cloud on title, and over and over and over, plaintiffs suggest that there's false misrepresentations. This is frivolous, that this is contrary to law, and it's just not true. And we can go through every single assertion in this affidavit. And I think
I'm reading the order since you directed my attention to the motion for reconsideration. I'm reading in the order, the judge says the defendants conceded at the hearing that the right to cure notice was not defective, and the pre-existing case law made clear that the defendants did not have standing to contest the validity of the mortgage assignment. So we have that concession, right?
I'd like to suggest that is not a fully accurate concession. I was not there. I sent.
We have that. That is our record. Can you point us to anything in the record that calls that concession into question?
I can point to the record itself. I can point to the actual affidavit and explain to you.
I'm talking about the affidavit. The affidavit the judge rejected as being false and not based on an accurate statement of the circumstances. And as to the right to cure notice, the judge recites a concession made at the hearing. There is nothing in the record to contravene or contradict that concession was made, unless you can point me to something.
I can point to the notice itself. I mean,
but the notice itself was the subject of that hearing, and we have a binding concession made at the hearing that waives that claim.
Okay, I disagree. I disagree with the judge's assessment.
We don't have to agree, Attorney McCarthy.
Let me put a finer point on this. I do want to hear you, but the judge found that the quote defendants conceded at the hearing that pre-existing case law made clear that the defendants did not have standing to contest the validity of the mortgage assignment. So before we get to the 5B affidavit, we have to get to the standing issue. And it says that issue was conceded by, I guess it was your brother counsel.
Correct.
And so where in the record can we find that concession is incorrect before we get to the affidavit?
The concession is specifically related to challenging the terms of a securitized trust. Okay, that's a concession that has to be made because that's the law. But that's
the validity of the mortgage assignment, for the judge's words.
It's not an accurate representation, because the allegation specifically by plaintiff is that the affidavit states that the violation of a securitized trust voids an assignment, and that is not in the affidavit whatsoever. It's a misrepresentation of the affidavit. And the fact is that the judge took verbatim at the oral argument, without even looking at the record, the oral allegations of the plaintiff, and just submitted a record order right then and there. I obviously cannot sit here
without a transcript.
I agree. I was not there, and I don't have the transcript in front of me. So it's part of the missing record, and there's nothing that I can do to change that. So I'd really just like to move on with getting to the substance. And I agree fully with the assessment regarding that missing piece of the case doesn't help. It doesn't help, obviously. And the transcript was not ordered. So we have to move forward on what's in front of us, and what's in front of me is a record affidavit that was alleged to be a cloud on the title, and when there was acknowledgments.
But that record affidavit is the subject of the dispute, and there were proceedings that reviewed and determined that affidavit was inaccurate. So we're going to have to look at the record to see the basis on which that assessment was incorrect. You're going to have to point us to something that establishes that the judge's determination that the affidavit was inaccurate was incorrect.
I can point you to the record documents and to the case law and show you why the affidavit is not incorrect, and there's no false material allegations within the affidavit, and it's all subject to good case law. I can plainly do that for you, and I'd like to do that. Whether it carries weight over the judge's order that was made on the docket is obviously in your discretion to make. But I'd really like the opportunity to at least present the facts behind the substantive issues within the affidavit, because that is the case. The entire case is a record document that's recorded on the land registry. And I think that the facts and the laws applied to the facts just needs to be made part of the record to some degree, because the allegations misrepresent the 183 affidavit entirely. And the record just needs to be clear whether the decision is in favor of my client or not. I want the record to be clear about this affidavit. And
what's in the record to demonstrate that the affidavit was correct?
The affidavit itself.
That's I'm sorry, but I think the way that story ends, the snake swallows his tail and disappears.
I mean, if that's your assessment, that's fine. But
you can't rely on the affidavit itself to establish that the affidavit is accurate. You have to. That was the entire subject matter of the contest in the lower court, and the entire subject matter of the challenge here on appeal. You're going to have to point to independent facts in the record to establish why the affidavit is true. You can't use the affidavit to prove itself. I see that Judge Grant has a question.
I have a question again about the judge's findings on the summary judgment motion. The judge said Attorney McGuire conceded that under applicable law, his client did not have standing to challenge the validity of the assignment. And then she cites to a case, U.S. Bank v. Bowling.
Correct.
Which is a 2016 case of this court.
Correct.
I couldn't find a cite to that case anywhere in your brief. So
in my brief?
I'm wondering, correct. I'm wondering, do you have an argument to distinguish that case, or are you saying that the judge's finding about Attorney McGuire's concession is inaccurate, or both?
No, that concession regarding Bowling is directly referring to a challenge to the securitized trust, which a client like mine, a mortgagor, doesn't have standing to challenge because he's not privy to that contract between two unrelated third parties. We never challenged the language or the terms of the trust. It's clear it was a manipulation of the language of this affidavit, and we had to concede that that's case law because it is, but that's not the challenge that was being made. So conceding something that's irrelevant doesn't matter that we conceded that fact, because it's not a fact that's within the affidavit, and that was the point I was trying to make.
Bowling's 90 Mass Ave Court 154. Is that the correct site?
It's within my sister's brief, but I think that's correct.
I want to make sure.
So that's regarding challenging the terms of the trust. And we acknowledge that you can't challenge the terms of the trust. Just because I outlined and referenced the trust, I never in this.
What is your challenge? I mean, I'm still, we're almost through your 15 minutes of argument, and I still am trying to understand, other than suggesting that the affidavit should be taken at face value in and of itself, despite the judge's conclusion that it misstated facts based on other record material. What is your argument?
First, I mean, the argument is that the notice of intent to foreclose is defective on its face, and it's in violation of strict compliance laws regarding the mortgage and 244 section 14, and it's indisputable. If you look at the 244 section 14 notice, that includes the 209 CMR certification, which is applicable law. It refers to a copy of the promissory note pursuant to Eden that must be included as part of that certification and that notice of sale to the mortgagor. It's part of the strict compliance requirements, and it's defective. It provides a note that doesn't have the proper endorsements, and is sworn to that it has this is the proper note with the endorsements. Plaintiff then submitted an allonge to the court, but it doesn't matter. Sure, they can fix the error before the foreclosure and renotice it, but as is, this notice was defective on its face. And paragraph 22 also says applicable to the statutory law, which includes the 209 CMR 1821. The Cranmore case that I cite in my brief is on point. The two cases cited by plaintiff are irrelevant to the point. So when they say there's no case law regarding this allegation, it's not true. This is a strict compliance element that was not followed. It wasn't strictly complied with, and it can't be argued. And that part of it was never admitted or conceded at that argument. So if we want to just focus on that one issue, which is the strict compliance issue with that chapter 244, section 14 notice, it's not strictly compliant. And if they had foreclosed and I challenged the foreclosure deed would have been invalid. And that's why I was clarifying title, because anyone who purchased that property after the foreclosure would take a bad foreclosure deed. And that was the reason the title was being clarified, because that would be bad title. And I could have got the foreclosure thrown out on this fact alone, never mind some of the other facts that we allegedly conceded or will admit to conceding at the hearing. So nevertheless, even with this one point, the clarifying the title is important to put the world on notice that there is a defect. You have to, at the time you notice the sale, these documents have to be accurate. These documents have to be strictly compliant. That's the law, and it wasn't followed, and it's clear on the record. And the case law is favorable to our position.
I see that Judge Nyman has a question, and your time has expired, but I will allow you to answer Judge Nyman's question.
Attorney McCardle, with respect to your Pinty argument, the SJC has issued its decision in Thompson versus JP Morgan Chase, and I'm wondering how that impacts your Pinty argument.
That part of the argument is out. I implore you to look at Fannie Mae versus Mariquin, which is 477 Mass 82, and look at the language surrounding May, M-A-Y, that waters down the Pinty notice, and then look at the notice that we've submitted, which says May in it. It shows that it is not strictly compliant, even if it gives you the right to a court action. If there's a condition on it that says it may be, conditioned on you reviewing your mortgage documents or the applicable law, it waters it down and doesn't provide an unconditional right, which is set forth in that document and in the mortgage, and would make that right to cure also non-compliant. And the reason we clarified title, because a foreclosure would have been non-compliant and the deed would have been void. So that's the reason we clarified title.
We'll have to leave it there. Thank you.
Okay. Thank you, Your Honor. Thank you for the time.
Sprague.
Thank you, Your Honors. May it please the court, Stephanie Sprague here for the appellee, Deutsche Bank, as trustee. And first, I think, Your Honors, I have pointed this out, but I will reiterate that many of these arguments have already been withdrawn and are not properly before the court. First, the motion to dismiss. I will not concede that I and my client were operating under the assumption that the motion to dismiss was going to be heard and decided upon first before summary judgment. In fact, I specifically requested the court give an answer, let me know whether the summary judgment schedule will be going forward, given the motion to dismiss that was in fact not docketed with the court. I didn't receive a response, likely because the court didn't have it on their docket. So in their mind, there was no motion to dismiss. And so I proceeded with summary judgment, and I did let Attorney McCardle and his firm know that as far as I knew, summary judgment was proceeding. So I will be filing my motion for summary judgment, and I did so.
Why don't we get to the record's going to reflect what it reflects. We have that before us. So why don't we get to the substance of whether it's procedural or substantive? Let's get to the argument as opposed to the notice issue.
Sure, Your Honor. So as far as standing, the original motion to dismiss was regarding my client's standing to try title. The Ron statute was put forth in that original motion, which was about land court's ability to hear try title, you have to have possession to hear try title. We're not requesting to try title. We're requesting declaratory judgment to say that this 5B affidavit does not in fact clarify title, and it does in fact cloud title. As the mortgagee, we have a title interest in this property. It's our mortgage, that's a title, that's property interest, that's title interest. We clearly have standing to ask the court to determine whether an affidavit that says my client isn't the mortgagee, doesn't have the ability to foreclose, that is clouding our title as mortgagee. And we do have standing to request the court make a determination on that. And the court in this case, although the motion to dismiss was not docketed, they did hear arguments regarding this at the motion for summary judgment on the initial standing issue. And it's reflected in the judge's decision that yes, the 5B affidavit does cloud title. It does not clarify title. It looks like it was actually created with a specific purpose to cloud my client's title. And that's why we have standing to move forward with the case in the first instance. And the court said that here.
That's maybe a distant cousin, but a cousin to the argument that we sometimes hear about evidence that's prejudicial. The mere fact that it's prejudicial doesn't mean that it's inadmissible, because if it bears the fact that it clouds your title, if it is an accurate statement of what in fact is a cloud on your title, it is a permissible affidavit to record, right?
If it did actually clarify title, then yes.
Well, even if it clouded the title, based on a valid challenge to the title, that would be permissible, right?
It might be. I wouldn't concede that, but that's not what we have in the facts of this case.
So tell us why it is that the specific challenges to your title, to your client's title, made in the 5B affidavit were invalid and therefore immaterial and properly struck from the record.
Sure. So first, the assignment of mortgage. Although my brother says he has some unknown challenge to the assignment of mortgage that could void it and not render it merely voidable, that is not in the 5B affidavit. That wasn't in anything in the lower court or this court. What his challenge actually is to the assignment of mortgage. The only thing that we have is the 5B affidavit, and paragraphs 9 through 12 of that 5B affidavit are what deal with the assignment of mortgage, and it's all about the pooling and servicing agreement. And here's the pooling and servicing agreement. It closed on this date. The mortgage was assigned on this date, and MERS had nothing to own nothing and had nothing to assign on that date. Therefore, it's void. That is what Bowling was. That was the Bowling case. The Bowling case came out 2 years before this 5B affidavit was signed by Attorney McCardle's.
That takes care of the assignment. Let's move on.
Yep. So the 35A letter, within the 5B affidavit and within the oral arguments on summary judgment, the entire argument regarding the 35A notice to cure letter was the Pinty issue. We read it together in court. Myself, I read it out loud. The judge read it along with us, and the attorney who was arguing the case read it along with us. And after it was read into the record, he conceded that no, that language does appear to be Pinty compliant and compliant with paragraph 22. Attorney McCardle is coming here today making some new argument that was not presented to the lower court, that the issue of may versus shall, that could be the problem with the letter. But today is the first time I have ever heard what the problem with the letter is, because when we read it in class and read it in the courtroom, the attorney who was there, rightfully and ethically conceded, I'm sorry, Your Honor, I didn't see that portion of the letter. It was on the last page. He hadn't seen it, and he conceded that, yes, that language does appear to be there. There does not appear to be anything wrong with the 35A letter, and that is what the judge did decide on the record. As far as the note, I would say, given the concessions, the note is really the only open issue at this time. The issue being, and in Attorney McCardle's brief stated that he believes there's an issue of fact of there are 2 copies of the note. It's copy 1 without the allonge, it's copy 2 with the allonge. Copy 1 was presented with the certification, and copy 2 was presented with my client's affidavit and other documents that were provided to the defendant upon his request. And to that, I would say there is no controlling case law that I know of that says 209 CMR 1821 certification is part of the strict compliance with the statutory power of sale. I don't believe there are any appellate level decisions on that, but there are lower court decisions on that, including the Butler case, which I did cite in my brief, which was my firm's case. So I was very, very familiar with it. And in that case, the court did say, we have been presented with no law that says this is part of the statutory power of sale. That strict compliance is required, and we find that it's not. That is a district court case.
Did any of those trial court cases actually address the substantive issue, or did they merely just say there's no appellate case that says so?
They did. They found that there is no appellate case that would plausibly say that this is part of the strict compliance. It's It's added with the Chapter 244, Section 14 letter, and that's what the certification requires. It requires you to put it in the same envelope. It does not, there is no case that I know of that has overturned a foreclosure based on that certification.
Prior to Eaton, there was nothing in foreclosure law that required production of evidence of the note itself.
Yes, Your Honor, and Eaton didn't actually require it. They said you did have to hold the original note, would be the agent of the note holder. They suggested very strongly for title purposes, you might want to do an affidavit, but it didn't require an affidavit to be put on the record. And that's important here too, because this 5B affidavit is claiming to clarify title. The 1821 certification is not recorded. It's not on title. So it can't clarify title to challenge a certification that is not on title. Beyond all of that, the foreclosure hasn't happened yet. We could still transfer the mortgage. We could transfer the note until the foreclosure happens, until that notice of sale goes out. That is when we need to have both possession of the note and the mortgage. But in this case, we do. We have possession of the note with the allonge to blank to my client. They have physical possession of the original note. We put that in our affidavit. And we also, in our discovery responses, offered to allow the defendant and his counsel to come into the foreclosure attorney's office, who physically holds the note, and come look at it. As the judge noted in summary judgment, they did not avail themselves of that opportunity to come actually look at the original note to assuage any issues or any concerns they had that perhaps the launch wasn't really attached or that this wasn't really the original note. Any fears they had regarding that could have been assuaged by them by actually coming and looking at it. And we did offer that opportunity to them. So I would say virtually everything in the 5B affidavit is either untrue based on the facts, untrue based on the law, or simply does not clarify title. There's nothing on title with this certification. It doesn't clarify it. The purpose of the 5B affidavit would be, so they put in the wrong number somewhere in a deed or a mortgage, or the wrong amount, the wrong date. The affidavit, when they certified it, someone wrote the wrong initial, something like that. That's what the 5B affidavits are for, and that's what Bank of America versus Casey says. That's the purpose of the 5B affidavit. The purpose of a 5B affidavit is not to put forth a challenge to a potential impending foreclosure on a defaulted mortgage. They can, and borrowers very often do, as is their right, bring affirmative case challenging something regarding the impending foreclosure, or they can challenge it at an eviction. There are opportunities to bring these challenges, but the 5B affidavit is not how you do it.
Just curious whether in your view the disposition of this litigation surrounding the 5B affidavit would operate in any way to bar the assertion of one of those claims in the subsequent litigations you've just described.
No, Your Honor, I don't believe that's necessarily what our complaint was requesting. We were requesting to make the 5B affidavit null and void.
So so should you proceed to foreclose with this affidavit out of the way, the borrower remains free to challenge and seek injunctive relief and challenge the validity of the foreclosure as things go along.
If they have a legitimate reason to do so, then yes, Your Honor.
Well, I mean, on these same grounds.
Yes.
Okay. All right. Do you have anything else you want to tell us?
No, Your Honor. I will rest on my brief. There's no further questions.
Looking across the screen, I see none. The case is submitted. Thank you both. That concludes the argument in this case. Go.
All right, we are now live and recording.
The next case on our hearing this morning is case number 2019 P1814, Cashman Equipment Corp. versus Mata Global Advisors, LLC, and others. Mr. Deptula, you may begin.
Yes, thank you, Mr. Chief Justice and members of the panel. I'm George Deptula, representing Cashman Equipment Company in this case. The case, as you know, involves what appeared to be a legitimate claim for damages as a result of a wrongful self-help lockout of Mr. Cashman on July 1st and turned into a rejection of that claim and a finding of fraud on the court because allegedly there was some form of false damage claim made and put in an answer to an interrogatory. I want to first address the fraud on the court issue here, Your Honors. That requires the most egregious form of conduct under the case law, an attempt to defile the court and materially falsify usually the entire merits of a claim, which must be shown by clear and convincing evidence. What happened here was a bungling, mainly by CEC's, Cashman's counsel at the time, which can be shown if you look at just the answers to interrogatories, one version of which was signed by counsel, not by the client. There's an answer to interrogatory number 5 that sets forth kind of a proper measure of damages. Interrogatory 8 does not. There was a mistake on a lease form that was produced that was acknowledged and really didn't go to the basis of the court's findings. But nothing in that conduct amounts to a defilement or justifies any award of $190,000 in attorney's fees.
Mr. Deptula, as I understand it, the concern that animated the judge's conclusion seemed to be that there was a representation made that there were monies lost out of pocket when in fact it was an internal transfer from the right hand to the left hand. And the judge was apparently outraged by the representation that a transaction that was presented as a third-party out-of-pocket loss was in fact nothing of the sort.
Well, it was not presented as a third-party loss. It was well disclosed that it was an affiliated entity. And what happened here is that
well, how is there a basis for a claim for damages if it's an affiliated entity?
Well, why not? I mean, I don't think because an affiliated entity owns other property that they're deprived of damages.
But weren't the funds later reimbursed?
Well, no, because there was a debt of $2.8 million that affiliated entity owed. So the rent was paid and it was used as a pay down of that debt. So in the end, Cashman Equipment Company or Mr. Cashman lose that money as they have basically a debt that gets reduced or a mortgage that gets reduced in amount. So
I thought there was evidence, I'm sorry, I thought there was evidence to the effect that either CEC or Cashman gave, was it two $200,000 payments?
Yes.
And then received back two $200,000 payments?
Well, they received back the, I mean, what happened is that they made the payments, which were for 4 months under the particular lease that had been agreed to take it up at that rate. And that rate was established by hotel rates. The repayment did not, it's just a method of reducing the debt that was owed Cashman Equipment. So to Cashman Equipment, they lost the money in the long run, but they didn't have a cash flow problem because, I mean, they gotta, I mean, it's, if you rent someone property from someone and say, pay this rent, and they say, well, but you better pay down your debt, there's a loss of money. It just is deferred over a period of time. But, you know, the whole—
I'm having difficulty seeing how those are damages.
Well, you know, it's a damage because Cashman Equipment had to pay the rent for that time period.
There could be a lot of creative using that methodology. Yeah. Boy, people could really assert claims for hundreds of millions of dollars of damages based upon some money that they owed to their own lender.
I remember sitting many years ago around a conference table at in a troubled debt restructuring, and someone uttered the words, "Cash is fungible," and it sent a shiver down my spine.
Well, I think the problem, if you go back to the fundamental problem, he's locked out of the place. He has used that location and rented it for several years. Cashman Equipment Company makes available a place for all kinds of different business purposes, and some plan some random people that they can invite to Nantucket over the summer. So he is out there. He cannot, they made a diligent search for some alternative, which they couldn't find. The only alternative they could find was hotel rooms. And that's
paid that money. The judge found he paid that money. He got it back, and his representation to the court that he was out of pocket for that money was false. Now, the effort to characterize it as being a legitimate payment on account of an unrelated legitimate debt is something that the judge, at least tacitly, rejected as a matter of fact. Aren't we bound by that unless it's clearly erroneous?
No, I don't think she made that finding at all. In fact, that she accepted the accounting that it was. She just said the amount was, so high that that she thought that constituted the thing of fraud in the court. If the damage theory is wrong, that's not fraud. I mean, an exaggerated or wrong theory of damages that the person wants to bring forward is not fraudulent to begin with. And second of all, it's certainly not fraud on the court. And it's a suggestion of a theory of damages. I mean, I don't see that any way, like the argument is made, well, it shouldn't be based on hotel rates because they didn't rent the hotel. Well, they did something that was the equivalent. And, it's very simple to correct that. If that's the correct argument, it's very simple just to move to strike that amount of that answered interrogatory as unresponsive. It doesn't require, it doesn't amount to a fraud on the court, and it doesn't amount to really something that should nullify.
But wasn't there also deposition testimony regarding these payments? And
I'm sorry?
Wasn't there also deposition testimony regarding these payments, and wasn't there all and regarding these alleged damages, and wasn't there also obviously production of documents regarding these alleged damages? It strikes me as more than just an interrogatory response is the point of my question.
Well, no, the deposition testimony when Mr. Cashman was disposed, he stuck by that theory. That isn't what the judge found wrong. She found that the amount was too high and somehow that was fraudulent. She did not accept the mistake on the lease that was produced with the set of answers to interrogatories that the attorney signed, not Mr. Cashman. And if you look at interrogatory number 5, it does set forth that the damages were only for 1 month, and the amount could very well be high, but you don't know. This is in the middle of holiday season on Nantucket, and they couldn't find another place. So
I have a question regarding some of the post-judgment procedure. There were a series of motions and a series of proceedings, including some that extended beyond the filing of the suggestion of bankruptcy. And in one of those, the judge entered an order finding the basis for attorney's fees under Section 6F. You challenge on appeal the propriety of that order on 6F, but it's not clear to me that, first of all, it's not clear to me what was going on with all of these things happening after the bankruptcy. But setting that aside for a moment, it's not clear to me how that question even is in front of us, because the notice of appeal had already been filed, and there was no separate notice of appeal. In any event, a notice of appeal from a 6F order would be to the single justice under 6G, and there is none of that either. What are we to do with that?
Well, I think that I think nothing can happen after the bankruptcy. And I think that the 6F finding, there was no basis for reverse.
We don't have jurisdiction over that, right? It's not in front of us because it was not the subject of the notice of appeal. The notice of appeal had already been filed, did not encompass this. And in any event, there's a different procedural vehicle. So the question, is you may have a basis based on the automatic stay under bankruptcy to challenge that 6F order, but it isn't here.
I tend to differ with that. I think the notice of appeal covered every issue that could be allowed in the case, and there's a stay of bankruptcy. And I think
let me back it up again. I covered this, but let me do it a little bit more slowly. First of all, the notice of appeal preceded the order that we're talking about. That's number one. Number two, under 231 Section 6F and Section 6G, the avenue to challenge by appeal an order under 6F is by an appeal under 6G. The time period to take that challenge, to take that appeal, is 30 days by statute. It may not be enlarged by court rule. And that appeal goes to the single justice, not to the panel. So as a threshold matter, we do not have jurisdiction over any challenge that you may now wish to make to the 6F order. Whether it is void ab initio because of the bankruptcy stay is a separate question, but that's not in front of us today.
I hear what you're saying. I just think under the special circumstance of this case where the notice of appeal was filed, then there was a bankruptcy proceeding, then there was a request to go forward with all the appellate issues, that subsequent request that identified all these issues should be sufficient under a 6F, and it's really.
Do you have any case that's
it's the first, unfortunately, it's the first time it dawned on me, but I'll be looking.
I mean, you know, our jurisdiction, I mean, I understand that you'd like us to take it up, but, you know, we do have to pay attention to the jurisdictional boundaries of we have in front of us.
Well, I do think it was a decision made contrary to the earlier decision that rejected 6F. And
I understand that.
Was made.
Judge Grant has a question for you.
Sure. I have a question as to Judge Fahey's memorandum on CC's motion for summary judgment. This is at appendix volume 2, page 74. She found that your client, the plaintiff, held only a sublease, not an assignment, and also that when he held over the sublease, he became a tenant at sufferance. Are you quarreling with those findings?
Oh, yes, of course. This is not a tenancy at sufferance by any stretch of the imagination. The core of her finding was finding that she wasn't an occupant or a tenant, but he had a prepaid lease. He left his stuff left his property on the lease, was denied access to it, and there is no, and the lease itself was assigned because the whole interest was assigned under the Marcel case. There's no basis for concluding that he didn't have the right to re-enter on July 1st as a continuation of a lease that he had prepaid for. I mean, that's clearly that he had paid for the whole thing. A blackout period does not in any way affect that. It's just, this is wrong, completely wrong on the law.
Well, I have another question about the lease or sublease or assignment or whatever you want to call it. From what I could tell, the only copy I could find in the record of that is the one at volume 1 of the appendix, page 145. And that version of it is not signed by your client. Is that a valid contract if it's not signed by your client?
I think it was accepted. I thought that there was one copy of it that was in the record, but I think there was an admission that it was signed. So that it was, signed and performed. I know there's a lot of handwriting on one of the copies, and I would just have to. I thought there were a couple different copies, but there was admission that it was signed.
But we don't have a copy that's signed in the record.
I would have to double check to see if that's the case, but I think there is testimony that it was agreed and that it was signed.
Okay.
39 seconds left. Anything else that you'd like to tell us?
Well, I just want to say, that fraud on the court requires some form of hidden scheme, some concoction. If he's wrong about damages, that's not fraud on the court. And it isn't. And if there's a mistake in an answered interrogatory, it should be stricken, or it can be taken care of by much cheaper ways than spending $190,000. And you can't add $190,000 as an appropriate amount on a case that basically had merit and could be dealt with in the Carragher case, Wojciech versus Carragher. They talk about kind of what you should do to investigate these things and not say that you get your attorney's fees for the entire case.
All right. Thank you.
Thank you.
Attorney Wetzel.
Good morning, Chief Justice Ryan and Justices Nyman and Grant. My name is Christine Wetzel, and I represent the defendant appellee, CCN LLC. And CCN here is to defend both decisions of the lower court, the summary judgment decision and the fraud in the court.
Why don't we start out where your brother left off? You've heard his argument about the fraud in the court finding and a simple disagreement about the appropriate level of damages.
With respect to the fraud in the court, this is much more than an answer to one interrogatory. Cashman put forth an excessive claim for $300,000 in damages for 3 weeks of accommodations. He supported that with a lease at $100,000 a week. He presented this lease as an arm's length transaction when in fact it was not. He had total control over Codfish Park and Bayou Holding. He lied in his deposition testimony, denying he had control, and he and his team made concerted efforts to impede CCN's discovery throughout this process. He suggests that this lease, this relationship between Cashman and Bayou was well disclosed. It was only disclosed after we conducted extensive discovery through deposition testimony of his team, which contradicted his testimony where he said he had no control. His team said he had total control. We did a title search, which revealed that he had taken a personal mortgage on the property, which involved Bayou transferring the property to him for $1. He got the personal mortgage, and 2 weeks later, he transferred the property back to Bayou for $1. So please make no mistake that this relationship between Cashman and Bayou was not at all disclosed by Cashman. It was only disclosed through extensive discovery. With respect to his raising the issue of damages, in the court's opinion of fraud in the court, she ruled that CCN would be entitled to damages for all of its efforts in researching, conducting up to 9 depositions, doing the title work, doing numerous subpoenas, that CCN would be entitled to damages for that. Later, following, and this was before the filing of the notice of bankruptcy, following several motions, she amended that and said that from the beginning of this suit, CCN was on notice that the damage claim was $300,000 and therefore was entitled to damages because of the fraud. The decision post-bankruptcy that you discussed momentarily a little earlier, while that was a decision where she changed her ruling on 231-6F, it did not increase the damages, and clearly her award of attorney's fees was found prior or determined prior to the notice of bankruptcy. Cashman's argument now that this was simply a mistake, that it was not fraud in the court, is an argument that they make new to you at the appellate level. This was never argued to the lower court. There were 2 hearings on this issue of fraud. At the first hearing, Cashman argued they should have their day at trial. They wanted to put forth a strategy to prove their theory of damages. They never said this isn't fraud. They never said, oh, gee, we made a mistake. The amount is wrong. We'll reduce our demand. Then they hired 2 new attorneys who filed multiple motions. And at a second hearing, particularly addressing a motion requesting a further evidentiary hearing, they were asked, so what evidence do you want to present with respect to the fraud or disproving the fraud? And they had no evidence to present. They now say to you, oh, 3 attorneys made the mistake of miscalculating the weekly amount. There is nothing in the record to support that claim that 3 attorneys made a miscalculation. And at that second hearing, they didn't say, we want to bring Mr. Cashman in. We want to bring attorneys in so we can explain to you that this was a mistake. It was an argument that was not made at the lower court, and it's really not credible. The only mention at the lower court that there was some kind of mistake was Cashman's deposition testimony, where he said he had a communication problem with his CFO about the amount. We attempted to corroborate that when we deposed her, and she said, I had nothing to do with the lease. His general counsel, who said, I draft all his leases, denied that he drafted this lease. So our efforts to corroborate his testimony were not successful. If you look at the lease of 12 Codfish Park, which appears in the Record Appendix, Volume 1, page 230, you'll see on the face of it, it is nearly impossible to miss the calculation here. The lease specifically says the period is July 1 to July 22nd for 3 weeks at $300,000 for that period. Then there's 3 lines underneath there. The first line says $100,000 to be paid by July 1, $100,000 to be paid by July 8th, and $100,000 to be paid by July 15th. To buy their argument there was a mistake, you have to believe that both Mr. Cashman and his CFO, Kim Shaughnessy, signed that lease and didn't notice the mistake. And also testimony shows that lease was sent to 2 attorneys, Attorney Kyberg and Attorney Wykowski. They didn't notice the mistake. Attorney Wykowski testified he was surprised by the amount, but nonetheless, the lease was submitted in discovery to support this excessive claim for damages. Now, Chief Justice Green, you had raised the issue of this exchange of money going from Cashman to Bayou. We discovered that through keeper of records subpoenas to the bank. They only gave us the 2 checks that went from Cashman to Bayou. So we subpoenaed Bayou's bank and found these 2 checks that was sent back within days of their receipts for payments for a non-refundable lease. We conducted 2 30v6 depositions of Andrew Saunders and Kim Shaughnessy to try to find out what was the explanation for that exchange of money. And Kim Shaughnessy, the CFO who handles all this stuff, in her deposition testimony said, well, I'm not sure, it might be a loan. I have those records in the office, although we asked in a Schedule A with the deposition subpoena for exactly those records, those company books and ledgers, and they did not bring them to the deposition. We asked at the end of the deposition if they would submit them later, and they never submitted them. But at the 11th hour on the hearing for fraud, they present an affidavit from Kim Shaughnessy that supposedly explains all this and explains the ledgers, but they never produced the documents to support that affidavit. And we suggest that that's just one example of their concerted efforts to impede our efforts to discover the truth. The other point that I would like to respond to that Attorney Deptula makes is that this could have just been handled by a simple motion to strike, that would have been the appropriate remedy. He's relying upon the Wojcicki case, which is a case of this court that found that there was no fraud, but there was misleading testimony of an expert witness. And the court said in that instance, striking or presenting rebuttal evidence or a vigorous cross-examination would have been the appropriate remedy. However, the court never said that where you have a clear case of fraud, a clear case of a party trying to put forth a fraudulent claim, that you just move to strike. So we suggest with respect to the fraud, the lower court found by clear and convincing evidence without any clearly erroneous conclusions that Cashman put forth this excessive claim. He supported it with a document that he had total control over, putting forth an exaggerated amount for damages, supported that with false testimony, and impeded our efforts to discover the truth, to disclose what you have before you now. And therefore, we suggest that that decision for fraud and the court's remedy should be affirmed.
I have a question on a different issue. Can you explain how it is that Cashman was not an occupant who was entitled to a notice to quit? I mean, it seems to me, I'm a little concerned that your argument sort of renders this a game of tag. Do you understand the nature of my question?
I think I do, Justice. Occupant is defined in the Carlson versus Boudreaux case as not, quote, not merely the person who physically occupies the building, but the person who occupies it as a tenant. And Cashman not only did not physically occupy the premises, but he was not a tenant on July 1st. And how that came about was that there was an interruption period in the lease, and Cashman was not in the property for the last 10 days in June. as a
This is,
result.
let me see if I can understand this, because I used to do a fair amount of leasing. This is a funky kind of lease.
It is.
As I understand it, Cashman, though he claims now that he was an assignee of the prime lease interest, he was as you describe it, a subtenant, and the prime tenant, Mata, was in occupancy and was entitled to be in occupancy for the days that are at issue here. And so at that time, it was Mata that was the occupant, and they surrendered their rights. Is that correct?
It is not completely correct, Your Honor. Our position is that this was a subtenancy, but for that 10-day, all the interruption periods in this lease gave possession of the premises to the owner, Mr. Penny. In his lease, he withheld these blocks of time so he could come in and use the property, and Cashman and his guest had to be out. Mata, as the tenant, had to relinquish possession to Mr. Penny. But to get back to, I hope I can answer the question about why Cashman was not an occupant. On June 27th, Mr. Penny had possession of the premises under this interruption period. On that day, June 27th, Cecine purchased the property, and he lawfully took ownership and possession from Mr. Penny. On June 30th, Cecine noticed Mata with the notice to quit, as permitted in the lease. A sale had occurred, and with a 30-day, and it allowed for a 30-day notice.
30 days.
30 days. On that same day, Mata surrendered his rights, communicated through his counsel to us that, and it's supported by his deposition testimony, and it's not controverted by the other side. He gave up all his rights, and this brings this case under the ruling, and your ruling at Applebee's, where a tenant who involuntarily surrenders his rights, it not only terminates the tenancy of the tenant, but it terminates the tenancy of the subtenant. So on June 30th, when Mata gave an involuntary surrender of his rights, it terminated Cashman's tenancy. So occupant requires a tenancy. At that day, on June 30th, Cashman was not a tenant. Also the statute, and put another way other than saying physical possession, Allendale Farm, which is a case that was cited by Cashman in his reply brief, which I couldn't reply to, so I don't have a cite in my papers, but it's Allendale Farm. It's in his reply brief. It's an 8 Mass Law Report. It's a Superior Court case. It says, quote, in order to violate the statute, possession has to be regained by force without benefit of judicial process. Cecine did not regain possession from Cashman. Cecine gained possession from Mr. Penny, who was in possession of the property on June 27th. So because Cashman did not have a tenancy and did not have a possession, this cannot be a violation of 186 Section 14. Now, this may seem like an unfair result to Cashman, but Cashman's action is against Mata. Mata didn't preserve any rights Cashman may have had to that 30-day notice to quit. And Cashman did sue Mata in this suit, and they reached a settlement of all claims. To overturn the summary judgment decision, I suggest that this court would have to overturn its ruling in Applebee's and conclude that Mata's surrender was not involuntary. And it would also have to ignore the longstanding definition of occupancy, as we find in the Carlson case, and the language in Allendale Farm that says that there has to be a regaining of possession by force, which wasn't present in this case. I would like to make one point about the decision by the lower court. The judge said that Cashman had a tenancy by sufferance, and the judge also said that he therefore was not entitled to judicial process. We concede that that part of her decision was not correct, that if he was a tenant at sufferance in July 1, he would have been entitled to some judicial process. However, he could not be a tenant on July 1 because he didn't hold over or retain possession. He did possibly become a tenant at sufferance later in July when he was given possession by a court order. So here, there's not a violation of 186, section 14 on July 1. CC rightfully maintained its possession.
I think we'll have to leave it there unless there are further questions. All right.
All right, we are now live and recording.
The last case on our list for hearing today is case number 2019 P1620 Niru Chawla versus Rajesh. Case on our list for hearing today is case number 2019. If one of you still has a separate feed open, I would ask you to mute that or close it out. This case is partially impounded. I will just remind you, this hearing is open to the public, and so please refrain from reference to any of the sensitive impounded material. With that, Attorney Smith, you may begin your argument.
Thank you, Mr. Chief Justice, and may it please the court, my name is William Smith. It's my privilege to represent Mr. Chawla in this matter. I would like to start off by saying what our argument is not. I mean, I think it's quite straightforward, but what it is not is we're not making any claim that the judge was bound to divide the estate, perfectly equally 50-50. I understand fully the case law says the judge most certainly was not required to do that. But the judge said, I have concluded that a roughly equal division of the marital estate is equitable after considering the factors of 208 section 34, which is fine. And then the judge had also found the plaintiff wife shall retain her public employee pension with the Commonwealth. But in the judge's findings, the judge said that after this multi-day trial that was held, he specifically found that the value of that pension was, quote, uncertain. There was certainly testimony here that in November of 2014, that state employee pension had a balance, I believe it was $24,000. So the salient issue I would suggest is, well, if the judge found that it was uncertain as of the time of the trial, as of the time of the findings being written in 2019, then does the finding actually support the ultimate division?
Mr. Smith, as I'm sure you're aware, judges in the probate and family court are rather often confronted with the need to incorporate in their division of the marital estate certain assets that are of uncertain value. That at least includes future interests, expectancies, interests that haven't yet fully vested. There are any number of different or assets that are, for one reason or another, difficult to value because of the character of the assets themselves. The mere fact that an asset is identified and acknowledged to be of uncertain value does not, for that reason, derogate from the ability of the judge to make what is designed to be a roughly equitable division of the marital estate, right?
Well, I would suggest it depends on the asset, number one. Obviously, if we were here, we were talking about a $200 asset or something like that, different story. But the very essence, the very concept of equitable, I think means fairness. Doesn't necessarily have to be equal. I understand that.
Well, let me ask you a different question. I mean, to the extent that, I don't know what the value of this asset is or was at the time of trial. The record doesn't really tell us very much about it. And so whether it's a $200 value or a $200,000 value is something that, because it's not in the record, we really can't allow that question to bear on our consideration of the issue. But accepting for a moment your suggestion that it is in fact a substantial asset, whose burden was it in order to present evidence of the value of the asset at trial?
I understand, and I think I sort of anticipated that question. Sure, absolutely, I understand. It should have been presented by my client's counsel as a different attorney. But the fact is, once we have a finding that says it's uncertain, and the judge is also at the same time, I'm not being critical of him, but just analytically, he's also saying at the same time that what is proper in this case would be at least a roughly equal division of the assets. Then we're left with, well, how can that really be? How is that possible if one of those assets, and certainly at least a major one, is uncertain.
Well, again, the description of it as a major asset rests on assumptions that are not substantiated by any evidence in the record, right?
Well, but certainly by inference, Your Honor. I mean, the valuation of the pension as of the time of the testimony, which was volume 4, section, strike that, volume 4, page 51, was $24,000. So I don't think it's an unreasonable inference that those years later, some 5 years later, it would be worth more.
Well,
So
I have a question for you about the passage of time. As I understand it, in Judge Johnley's findings and rulings, he said that he was using a valuation of your client's 401k back in 2014 to be fair to your client, because he'd added to it, or it had appreciated substantially between then and the time of trial.
right.
How do we know that if there, assuming for the sake of argument that there'd been evidence elicited as to the current value of the wife's pension as of the time of trial, wouldn't it also be likely that your client's 401k would have possibly skyrocketed by the time of trial? And how can we say that it's not equitable? What the judge did is to say, well, we'll take the husband's 401k as of 2014 and we'll let the wife keep her pension. And that's likely to be more beneficial to the husband, maybe, or at least equitable, roughly equal, than it would be if we had it down to the penny as of the moment of trial.
I think that's a perfectly rational, perfectly sort of logical paradigm. But the problem is we just don't know that here. I mean, if the judge is doing an equitable division of the assets under 208, section 34, certainly the judge has a great deal of leeway. Certainly he's not required to do it equally, 50-50. Equitable might not mean 50-50. But what we are saying here today is that there cannot be an equitable division pursuant to a roughly equal division, to be more specific, when that kind of an asset, it's just uncertain.
Even where the failure, that uncertainty is solely attributable to a failure by the protesting party to present evidence on the point.
Well, I mean, I don't think it's a question of fault. I think if the judge in his findings had said, well, I did not hear anything vis-a-vis, the current, as Justice Grant was getting to, the current value, that would be one thing. But that's not what the judge found. The judge found that it was uncertain. So what I'm simply saying is that given that finding of the court, I mean, we can't just disregard the findings of the court that sort of like, tilt in one direction. And the judge found that the value was uncertain. So we simply don't know.
But by the same token, we also cannot, in our assessment of the overall equitable division of the marital estate, focus solely on the wife's pension and the husband's 401k. It all has to be considered in a much broader context.
Oh, I 100% agree. And what I'm saying is that process cannot happen when one of those assets is uncertain. The judge found it was uncertain.
But when the husband doesn't present evidence about the value of that asset, what is the judge then to do? You can't possibly be arguing that the judge may not conduct a division of the marital estate when one party who has the burden fails to produce any evidence of the value of an asset.
Well, no, but what I am suggesting is what the judge then would logically have found is he would have said just that in his findings or something to that effect. But and that's not what he did here.
Going back to Justice Green's question, Chief Justice Green's question. During discovery, did your client, and this is depositions, interrogatories, requests for production of documents, whatever discovery was conducted, were there questions propounded regarding that pension and the value of it?
I mean, off the top of my head, I don't recall. I honestly don't. I mean, I went by what the record is and the judge's findings, as the case law says. So, that may very well be, I don't know.
So then my next question, is your client's underlying concern here that what was nominally a $22,000 or $24,000 asset as of 2017 may turn out to be, let's say, an $800,000 asset? Is that sort of the gist of this appeal?
Well, it was a 2014, not 17, Your Honor.
2014, whatever the date was.
Right.
Am I getting at the underlying issue?
But again, we simply don't know. It could be worth considerably more than that. There was an issue of, when it would vest, et cetera.
So I guess my follow-up to that is, suppose that in 3 years, your client learns that, wow, it turns out that this pension has vested. It's worth, throw out a number, $1.5 million. Would that be an appropriate basis to seek a modification of the judgment?
No, because I think that's factored in as of the time of the judgment. As Justice Grant had brought up the point with respect to my client's 401k. And by the way, we have no issue with what the judge did vis-a-vis my client's 401k. I'm not arguing that at all. So I think, no, I don't think in that hypothetical, Justice Nyman, I don't think no, I don't. But this is a different situation. All we're saying is,
I'm sorry, maybe my question, I meant my question to say vis-a-vis the wife's pension. Again, let's assume the pension turned out to be $1 million asset as of 3 years from now, for the sake of argument. It vested, turned out. Would that be a basis for your client to go back in and seek a modification of the judgment?
I don't think so, given the case law. I don't think so. Maybe that will change sometime in the future, but that's not my reading of the case law, Your Honor. But again, and above and beyond that, that simply is not the situation we have here. And I'm not being overly critical of the trial judge. I think it was a very long, very thorough hearing that the parties had. I think the judge made very detailed findings. But again, it's just that very basic but very fundamental question, which is, if part of this is uncertain, how can there really be an equitable distribution within the meaning of the judge's rationale, which is that it should be at least roughly equal. The judge could have done this and said, well, based on the 2014 valuation, I'm going to take that and then sort of do an offset with respect to my client's 401k. Maybe he could have done that.
Attorney Smith, I have a question about your second claim of error on appeal relating to the visitation schedule, the parenting schedule. I know that they use different rules of civil procedure in the probate and family court, but I believe my understanding is correct that Rule 60, and particularly Rule 60b-1, applies there.
I'm sorry, I couldn't hear that.
Doesn't Rule 60b-1 apply in the probate and family court to domestic relations cases?
Oh, from the rules of civil procedure.
Correct, or I guess is incorporated into the rules of domestic relations.
It is. I know the discovery provisions are, and I believe that is as well.
So the relief that you are asking from us on appeal is relief that, unless I'm missing something, was available to you or your predecessor counsel by way of a Rule 60b motion to correct a mistake in the judgment. And now you're asking us to remand it back, although the judge is now retired. Why in the world did you not take what you're now claiming to be a Scrivener's error back to the trial judge at the moment that the decree issued?
Your Honor, I didn't handle it below. I'm not trying to sort of wiggle out of that. The fact of the matter is, it's here on appeal. The counter premise to that is, well, we should have judicial economy. Why should it be litigated? Why should we have an appeal here on one issue and then?
Well, no, I understand that, but precisely that. The judicial economy hardly promotes the idea that you should bring it up here to ask us to direct it back to the trial judge when you had the opportunity to do so directly in the first instance.
Well, I guess the counter question would be, well, we're here anyway. Because
but in the meantime, the judge is retired, and the capacity for the system, if you will.
Well, we could say the exact same. I'm sorry, I didn't mean to cut you off, but we could say the exact same thing with respect to the main issue here too. Well, the judge is retired, so what do we do with that?
No. I understand that. I'm just I guess lamenting the missed opportunity to take an obvious and more direct response to the claim that you're now presenting to us. I'm not suggesting that we do not have jurisdiction or authority to consider the question. We can move on to that, but I just for the life of me can't understand why it's here.
Well, I would have, but it was not. It was Attorney Beauregard out of Lowell. It wasn't, it wasn't me. But in any event,
there's nothing personal in any of this.
I know. So, but in any event, I would just report to the court for whatever it's worth on that issue. I discussed that with my client. The parties reached an equitable, reached a mutually agreeable arrangement on that.
Well, that's the best news I've heard all day.
Right.
So
I'm just trying to get some good news in there.
So, so are you saying that that you have entered into a stipulation and we need not address that issue on appeal?
I would ask you to address it for the sole reason that at least it could be solidified by the trial court if the case is remanded. That's all.
If for some reason the parties get together and resolve this issue prior to an issuance of a decision on this case, would you please notify our clerk's office forthwith?
Oh, absolutely.
Thank you.
All right. All right. Thank you, Mr. Smith.
Thank you.
Mr. Hawks.
Thank you very much. May it please the court. I also have the privilege of representing Neeru Chawla, who I represented during the 8-day trial back in 2018. The court asked my brother a number of questions whether or not discovery was conducted on the issue of the unvested pension of the appellee. And indeed, significant discovery was conducted. A deposition was conducted. A court order for my client to execute a release so that the appellant and his counsel could obtain direct information from the Commonwealth of Massachusetts was actually ordered for that's docket entry 167 for this panel. I would also point out that the appellee was cross-examined over 3 days, volumes 4, 5, and 6 of the record appendix. That is a significant amount of time to be on the witness stand being cross-examined. Those dates took place on May 3rd, 2018, July 19th, 2018, and August 6th, 2018, which is more than an ample time period to prepare and ask pertinent, relevant questions about any and all manner of the division of assets. And my client was subjected to questions about retirement monies, bank accounts, and of course, her employment with the Commonwealth on all 3 days. But I would just cite to this court that only one question in those 3 days of cross-examination involved questions about her pension. And that was, again, my brother cited this, volume 6, page 50. And she was asked about what was trial exhibit number 9, her financial statement from November 17th, 2014, wherein she listed her pension value. Again, I know there's some questions about the value of the pension. And again, this is not an attempt to patronize this panel, but as employees of the Commonwealth of Massachusetts, and continued employees at this point, I think the trial court judge knew this as well. There needs to be a certain amount of employment, a time period of employment before a pension vests within the Commonwealth system.
Well,
and
that's not a proper subject for judicial notice. You're not suggesting that, are you?
No, I'm not, Your Honor. But I think
for that matter, I have enough trouble keeping track of the rules affecting the judicial pensions. I certainly don't know much about the state pensions for non-judicial appointments.
Right. Well, I would say this, that it was an uncontroverted fact that my client worked for the Commonwealth of Massachusetts for 7.5 years. This is Record Appendix Volume 2, line 18. She testified to being laid off on or about May 31st, 2016 from her original employment within the Commonwealth system. She then was reemployed a month, she was reemployed in the Commonwealth system within a month prior to the trial date commencing. So again, I would cite for this panel finding of fact number 39 by the trial court, which was wife's subsequent employment with another public entity allows her to continue to contribute to the public retirement system, it would appear that her public pension was not yet vested when she was laid off, but that it is about to vest if it has not yet done so. I would cite that the court did consider the nominal value of the contributions made by my client into her pension, both on that financial statement, as I cited and my brother cited, Record of Pendants Volume 2. But I'd also note for this court that there was an uncontested exhibit, Exhibit 37, again, agreed upon, which was evidence, documentation, or documentary evidence, which actually contained, and it was a statement from the Commonwealth of Massachusetts, which showed my client's contributions as of November 2014. So that was in evidence. I know my brother has cited to this panel in his brief that there was no evidence as to the value of the pension. And the reason for that was because there was uncontested evidence. So from our point of view,
Hawk, that was as of 2014. The question that the value of that asset does not cut off at the time of filing for divorce. The valuation of the marital estate, for most purposes, is a question to be considered as of the time of the division, right, at the time of decree.
I would say I would agree with you in most cases, but in this case, several significant factors were heavily weighed by this court, and that's contained within the findings and rationale. In fact, this court divided the husband's 401k as of the date of November 1st, 2014, 3 days prior to the divorce complaint being filed.
Right, but the judge offered, whether it was justified or not, the judge offered a transparent, explicit rationale for the decision to do so. The judge didn't do any such thing, any similar thing, with regard to the wife's pension or any other asset for that matter.
Well, number one, I would suggest to this panel that there was no pension per se. There was no evidence that a vested pension existed at the time of the divorce. The judge, in his finding, did not believe a pension had vested, and there was a question as to whether or not a pension had vested. That was within his finding. As of, I mean, it's not really before you, but so I'll ignore what I was about to say. But my point is this. The husband received the lion's share of the assets in this case. And it's inequitable for us to try to ascertain whether or not the judge intended to divide this pension or contributions to a pension, because he clearly considered all the factors and contained them all within a chart, which was his finding number 43 in the findings of fact. If you consider, and again, if you contrast the findings, number 47, the asset division chart, with the court's findings, which is Record Appendix page 25, findings 64 and 65, you can see that the husband's USAA account, his Capital One account, and his Scottrade IRA, he retained those in full. In every account he had, as of the date of the divorce versus the date of division or the date of the trial when the assets were valued, he increased the size of his assets significantly. For example, his Capital One account increased $12,000 from the date the court used, and this is finding 64, the date the court used at the beginning of the case versus the end of the case. His $2,000 in his Bank of America account had become $14,000. His Scottrade IRA at the time of the divorce filing was $25,000, had doubled to $52,000. These assets were not divided in the division, except for this 401k and except for the marital home. The husband was able to retain his IRA, his bank accounts. He had no credit card debt at the time of the trial. And same thing with my client. She was able to keep her IRA, her bank accounts, et cetera. So the judge thought and weighed all Section 34 factors. And again, if you look at Williams v. Massa, which is a case my brother cites, I would just point out that again, the court has considerable discretion. And so long as the judge shows that he has considered all the relevant factors, which I do not believe my brother has claimed he hasn't considered all the relevant factors, and his reasons or conclusions are flowing rationally, which I would suggest to this panel, they flow very rationally, because of the 4-year time period between the separation date or the filing date and the trial concluding, this division of assets makes financial sense. I mean, you asked my brother, you don't have any problem with the 401k division, or he said, I have no problem with the 401k division. I would suggest because in a sense, at the time of November 2014, and this is within the findings, the husband had about $150,000 in his 401k. At the time of trial, finding number 47, he had $300,000. So he kept all of the contributions, all the appreciation, all the employer side contributions, and only had to divide half of that account with his wife. So essentially he got 2/3 of his 401k, or strike that, he got 75% of his 401k, and my client ended up with only 25%. So it is equitable for her to get the very nominal contributions that she made to her pension account, which again, as you've questioned my brother, was discovery done? Indeed it was. Was deposition done? Indeed it was. Was a release signed? It was. They had all the information. Had they had any question about the veracity of her claims, the judge had uncontested evidence as to the level of contributions, the amount of contributions, which was uncontested evidence. And so this was well within the discretion of the court to consider, and he did consider it and heavily weighed everything.
With respect to the second issue,
yes,
it would be nice if this is an issue that could be resolved, since it really does appear to be, I suggest, a scrivener's error or an omission from the judge. But with that aside, are you contesting that for purposes of appeal right now?
I guess since my brother did note that the parties have been following an informal agreement since the pendency, or since this judgment was entered, and they've had 2 summers have elapsed and they've come to an arrangement on this issue. I don't know that my client wants me to spend a lot of time on it. I would concede that, I don't think my client believes that there's an issue that needs to have this panel consider. But I will say this, I think if you read the 2nd, 3rd, and 4th sentences of that specific judgment, it's pretty clear that what's being asserted by the appellant can't possibly be accurate, because it's
we're not going to enter a different schedule, but let me suggest to you that if your goal is to, on behalf of your client, to avoid the need for you to spend additional legal time to sort this out, the surest path to that objective is to enter a written stipulation memorializing the arrangement that the parties have agreed upon.
Agreed, Your Honor. Agreed. And my client would be more than willing to send
We will look forward to seeing it if the two of you can memorialize that promptly.
I would be more than willing to send a proposal over to my brother today at the conclusion of this hearing. I would do that immediately at the conclusion of this hearing.
Well, no coercion intended, but
no,
I will be deeply appreciative of whatever you can do to resolve this without the need to consume additional judicial resources, either at the appellate or the trial level.
Understood, Your Honor.
Thank you. Anything further on the first issue?
Yes, Your Honor. So again, and I would also point out, and I'm sure as Chief Justice Green pointed out when my brother began his presentation, that not having the value of having uncertainty as to the value of an asset does not inhibit a trial court from disposing of an asset. I would point out, and again, this is finding 47, that asset chart, which I think was very handy for this panel and all the parties that the trial court presented. The fair market value of the marital home of these parties in Westford had 2 different values within that chart. The wife believed the value was worth $477,000. The husband believed the value was $580,000. And that did not inhibit the court from assigning how that asset was going to be disposed of, assigning equity, withholding monies from escrow. And I would just point that out. I think that's a very important point because it.
Well, yeah, but that's not a pure example, because in that case, the easy way out of any uncertainty about the value, you sell the property and then distribute the proceeds net of the liens on an equal basis, right? That's what the judge did.
That is what the judge did, but I would also point out to this panel that the fact that there is a quote uncertainty as to a value of something does not prohibit something from being disposed of. And the court had the evidence, as I pointed out. They had that as an uncontested evidence, no no major cross-examination disputing those facts. The burden has to fall on the party seeking to controvert evidence or testimony to indicate that something was not done with a full disclosure. I would suggest to this panel that that asset was fully disclosed. The asset was not vested, and there was no testimony contrary to what I'm saying to you and what's contained within those financial statements. I greatly appreciate your time and willingness to listen to our argument, and I thank you for your instruction to resolve the parenting time issue.
Not an instruction, a suggestion, but we again will watch for that with great anticipation, and that will conclude the hearing. I thank you both for your presentations.